My name is Rick Barry. I am the director of FINRA's Dispute Resolution Services Program, and it's such an honor to have this amazing panel here today of law school professors who are overseeing these Securities Arbitration Clinics, which is a vital piece of the FINRA arbitration system because they do such great work. We are going to have rapid fire questions, one question for each panelist. Just a reminder, panelists, we have about 3 minutes per person, so I don't want to give you the hook, so please keep that in mind. And as you get your first question, please introduce yourself and mention what school you're with. Bruce, I'm going to start with you. How do law schools benefit from having securities arbitration clinics?
Oh, thank you, Rick. Happy to be here, and thank you for moderating this panel. I think there's several benefits to law schools for having investor education clinics, and I'm going to go through them real quick. Rick gave you 3 minutes. So I think it gives your students an opportunity to learn a very valuable skill, how to represent clients, how to work in financial services type environments, how you can work against opposing counsel, and they develop a lot of skills that they can use to benefit them in their legal careers. So that's one of the great benefits. They also go up against experienced opposing counsel. So therefore, they learn just by doing. All right, so those are some of the benefits for the students. They also benefits the school because now your surrounding community, you can help investors who are underserved, and it does enhance the reputation of your school and also connect you to your community. Employment prospects for the students, it really helps them develop skills they can then sell out to the marketplace when they want to go get jobs, and they can get jobs with law firms, financial services companies, SEC, FINRA, and other places. The other thing it does, it helps the schools attract students to the school. I've had some students call me who were thinking about applying to law school, and they said they chose our school because we had an investor advocacy clinic. So I think that's also a great benefit for the schools. And lastly, I'll mention donations. We get donations from investors. You know, we get money back for them. They give some back to us. We don't charge legal fees, but they do donate to the university. And also others who appreciate the work that the clinic does for investors, underserved investors, particularly retirees, they also donate. We've got some pretty substantial donations that way. So I think those are some of the major benefits. Rick, thank you.
Thank you so much. All right, Sam, is it difficult to start a securities arbitration clinic?
When I read the question, my name's Sam Tenenbaum. I'm with the Northwestern Pritzker School of Law, Investor Protection Center. When I read the question, I thought about a scene in the movie Moneyball. And for those of you who have seen it, there's a scene where they're at the home of Scott Hatteberg, a guy who's an injured catcher and has been out of baseball. And Billy Bean, the general manager, and Coach Washington, who coaches the team, come to visit him to convince him he can be a first baseman. And Hatteberg asks, well, how hard is it to switch? Billy Bean says, oh, it's easy. Nothing to it at all. You'll get right into it. And then the camera pans over to Coach Washington, who says, it's one of the hardest things you can do. And that's the range of what it means to start an investor protection clinic in terms of the degree of difficulty. But we do have tools that can help you. And up on the screen, you'll see there's a guide that I authored on how to start investor protection clinics. And it's been used by a number of clinics to help them get started. And it covers the whole gamut of issues that you'll have. It includes details about various aspects of starting a clinic. It also provides forms, documents, links, and one other key component, and that is all the folks here on the panel are willing to help. We're available to work with anyone who's interested in starting these kinds of clinics to get them started and continue operating. We all get calls from other clinics all the time, and we're actually a real close group of friends who work together. We get together once a year to talk about various issues, and it's a very close-knit fraternity/sorority. It's going to depend on a number of factors in terms of the degree of difficulty. One is there a need in the community for it. I can tell you, according to FINRA and the SEC, there is. And then the desire by the law school, having a professional lead it, funding, the range of work you're going to do, all of which other members of the panel are going to discuss this morning. So we need more clinics, and we're very hopeful that those of you who are at schools who are thinking about it will dive right in and do it.
Thank you, Sam. Nicole, so you got a Securities Arbitration Clinic up and running. How do you sustain them?
My name is Nicole Iannarone. I'm at Drexel's Klein School of Law in Philadelphia, and I have a experience unique to everybody on this panel. In fact, I'm the odd person out. I don't direct a clinic right now. I have both started and closed a clinic at another institution. And to Rick's question about how do we sustain clinics, the answer is support. And I don't mean just money. Obviously, money is a big part of any new endeavor that a law school would undertake. But I think having institutional support and ensuring that the people on this table who are running a new clinic have resources and have strong support from their administration is vital to sustaining a clinic. Sometimes I get students who say, I was told there wouldn't be any math in law school. And I get a sense sometimes that administrations can be a little bit afraid of securities arbitration clinics because they sound like there's scary math law involved in them. But for all the reasons you've already heard from Bruce and from Sam and what you're going to hear from everybody else on the table, there are reasons that these are, I think, one of the best possible clinical experiences. To sustain them, you need to know them. Law school administrators really want you, clinic directors, deans, get to know any of us. We are, in fact, a very friendly bunch who have lots of materials that we are happy to share. But having that relationship close within the law school, showing that there is continued support of the clinic and that the administration really cares about it is essential to them thriving. The rest of the stuff we can help you out with.
Thanks, Nicole. Alice, this next question is for you. What are some of the most common forms or models of securities arbitration clinics?
Good morning. I'm Alice Stewart. I am the clinic director at the University of Pittsburgh School of Law, and I run the tax clinic and the Securities Arbitration Clinic. And fortunately for the Securities Arbitration Clinic, Pitt has been very, very supportive, and we have an adjunct, Professor Rachel Shaw, that also works within the Securities Arbitration Clinic. I actually find this question very interesting because there's a lot of different options in terms of how you run a securities arbitration clinic. I started the Securities Arbitration Clinic in the year 2000, so I've been doing this for a little while, and I love it. And I think everyone on this panel absolutely loves teaching the students how to do securities arbitration, and in particular working with the small investors that we represent. So when I started my clinic, I started solely FINRA arbitrations. And over time, it evolved, and we started to comment on proposed regulations by FINRA, and the students really enjoyed learning the process and the importance of providing those types of comments, in keeping in mind of who their clients are, the small investor. There are a lot of clinics who may be run by adjuncts only, and I will say it's my belief that if you want a strong, thriving securities arbitration clinic, you should have a full-time clinician in the area. Prerequisites: business organizations or securities regulation, depending on how much is touched upon in business orgs. I require one of those two courses either as a prerequisite or they take it at the same time as they're taking the clinic because there just isn't enough time in the clinic seminars to teach the substantive work. A lot of clinics are 1 semester. I am 2 semesters because I think the students get a lot of basic information and interviewing skills in that first semester, and in the second semester they can start to represent clients. I want to stress the importance of these securities arbitration clinics. I have a short period of time. I'm trying to rush through this. It's good for your community, it's good for your students, and it's really good for your schools. It's an important program, and I'm very thankful that Pitt provides us support. And so, thank you very much.
Thank you, Alice. All right, Alyssa, this next question is for you. What is the status of legislation that would help fund securities arbitration clinics?
Thanks, Rick. I'm Alyssa Germain. I teach at the St. John's University School of Law. The Investor Justice Act was introduced in the 117th Congress in 2022 by Representative Mike Quigley of Illinois and Senator Catherine Cortez Masto of Nevada. The act, as proposed, would provide authority to the SEC to establish a grant program to fund qualified investor advocacy clinics with the SEC's already congressionally appropriated funds. To qualify, clinics that are associated with a law school must provide free legal representation to small investors, which is what we all do, in securities arbitrations and mediations of claims of up to $100,000. And that's pretty much most of our limits, because that's where the investors can't get a private attorney to represent them. The act would authorize awards to clinics of up to $150,000 per year, with the total amount aggregate of $5 million per year across all clinics. And the funding in the act differs from FINRA funding that we used to open several clinics in past years. The act would permit funding to sustain clinics. It would be ongoing versus limited seed funding that ended after a certain time period. In June 2022, the SEC Investor Advocacy Committee made a recommendation to the SEC that it support the Investor Justice Act. There was a similar recommendation in 2018 that was made for support for clinics. The bills have not yet been reintroduced in the current session of Congress, and so we're not aware of any action since July 2022, but we'll see where things go with that.
Thanks, Alyssa. Paul, one of the key questions involves students. How do these securities arbitration clinics benefit your students?
Thanks, Rick. So I teach at Fordham Law School, Paul Redvani. I think these have really rich learning opportunities for students. They get up to speed in one semester, and even if they haven't taken securities laws, I actually tell applicants that if they don't know what a security is, they can still take the clinic. And less than 1% of my students have gone in this area. So I think it's a great training for any kind of litigation-oriented students. They have many opportunities to advocate on behalf of clients, whether it's in writing detailed complaints or briefs, arguing motions, negotiating with experienced adversaries, and advocating at full-day mediations to settle their cases. Students also advocate at arbitrations. They make opening statements, closing arguments. They conduct directs and cross-examinations of their clients, of witnesses, of experts. And in a sense, arbitrations are a little easier than trials because the rules of evidence don't apply. And other than that, and the fact that there's no jury, it's very similar to litigation, very similar trial skills. And students learn how to investigate the case, and develop the facts, which I think is key for every litigator, and tell these great narratives of what happened in the case. And of course, they learn counseling skills. So most of their skills, like with many different clinics, are very transferable. And I like to think of the cases as wonderfully complex. They provide opportunities to make countless decisions, big and small, throughout the semester. As a result, students improve their judgment and decision-making. And I really believe that one thing that separates good from great lawyers is the ability to make important strategic decisions that benefit their clients. Students also have the opportunity to work with experts who help students understand their cases and build their case theory, and students prepare them and do their direct examinations. And finally, students have an opportunity to critically examine an arbitration system that is one of the most advanced in this area of any area of law. They gain an understanding how to advocate in a highly regulated area, and have opportunities through the common process and through meetings with regulators like today to influence proposed changes to regulations and procedures.
Thank you, Paul. Liz, I have a two-parter for you. How do clients benefit from having securities arbitration clinics, and how do the communities you serve benefit from them?
Great question, Rick. the Cardozo Law School Securities Clinic, and our clients would otherwise go unrepresented. I mean, that is sort of the biggest benefit that we provide. The cost of proceeding in arbitration or in federal court, where we sometimes are in securities fraud claims, would far exceed even the maximum recovery in many of our clients' cases. Also, our clients aren't always aware that there's an avenue for waiver of fees. FINRA has never denied a single fee waiver application we've made on behalf of a client. We charge nothing for our legal services, and our clients often never have to pay any sort of filing fees or any other fees. We cover discovery costs, we cover all the costs associated with their cases. But in addition to that, we provide outstanding representation, and I think I can speak for every clinic represented here today, because there is so much commitment, so much effort put into the representation of their clients. We have better records of recovery than even private lawyers at FINRA. We have, and our students will try these cases. They will try a $25,000 case like it's worth $25 million. No one spares the effort, and our clients also feel heard. I mean, one of the other things that happens in these cases is that they feel like no one's listening to them. They've been complaining, they've been suffering, they've lost everything they have that they've worked for, that they've put their whole life into to save, and no one is listening. No one is helping them, and we step in. We also are able to help communities in lots of different ways. In one way, we're the canaries in the coal mine. We'll talk to regulators about what we're seeing on the ground in terms of how small investors are being impacted by problematic sales practices or problematic products. Sometimes we'll also identify a fraud that has a much larger, far-reaching effect, and we'll refer those cases for criminal prosecution or for the SEC to take care of. And finally, we do outreach. We go into communities and we talk to them about how to protect themselves from fraud, how to help them in terms of promoting financial literacy. Basically, we're trying to put ourselves out of business. Thank you.
Thank you so much. I just want to ask a follow-up question. Anyone can answer, but let's start with how often, how many of your clinics do write those comment letters that was mentioned earlier to FINRA proposed rules? Raise your hand and then feel free to comment.
We did a lot of comment letter writing when I ran a clinic, and the great thing about writing comment letters is that Rick and his team has to follow up. So, they will and have actually, FINRA is so giving, they will come to the law schools to introduce themselves to students, to teach classes, and also engage with them about their comments. My students were absolutely floored when someone came to visit, pulled their letter out of a briefcase with a highlighted section and said, "Hi, I've been asked when I come here to ask you about what you wrote. Can you give me some more detail on this?" And they can also see that in the regulatory record. Their letter is impacting regulation. And FINRA tells the SEC how. They've read the letter, they respond to the letter, and that's incredibly meaningful work on behalf of a group that doesn't have a lot of lawyers or the money to come in and give a comment otherwise.
Hey, Rick, I can add one thing. I had a student, an applicant one time thinking about going to law school, and he called me and told me the reason why he was interested in Howard was because he saw a comment letter that we wrote and put on the comment register, and he was so impressed, he decided he wanted to become part of our clinic.
That's fantastic.
Plus, when we comment, we're like the tip of the spear. In other words, regulators, both the SEC and FINRA, rely on us to find out about what's going on the ground in terms of small investors who usually don't have the ability to comment on their own or have an industry trade group or anything like that. And we actually see the effects of certain practices and have actually a better understanding of how it affects investors than some of the other groups that are commenting.
And just a final note that we have made many, many changes to rule proposals as a result of these comment letters. So it is very impactful. All right, Scott, what do you wish you had known when you first started at a securities arbitration clinic that you now know?
Thank you, Rick. And I started directing or working at a securities clinic and right out of my first job out of law school. So I was 33 years old. I wasn't that much older than the law students that I was actually teaching. So what I had to learn, and I think what is important for all clinical professors to learn, is the difference between the gap, I guess, between how well you know something and how well you can explain it to a student, because that's where I found challenges. I thought I knew securities arbitration really well. I thought I knew the law really well until I had to go ahead and teach somebody to learn that area of law. So that was a big gap for me. Another thing, I'm going to echo a little bit what some other of the panelists have already said, which is that I didn't realize how much support there was out there in the clinical community, among securities clinics, also among like-minded attorneys. We have gotten a ton of support from an organization called PIABA, Public Investors Advocate Bar Association, where there are a lot of attorneys dedicated to representing investors and advocating for investor rights that have also volunteered their time for our clinic. Something else I didn't know at the beginning when I started working at the clinic is the freedom that you have. And I came from a background of working in a big law firm practice, and you pretty much are doing, what you're told in those practices. In the law clinic environment, you are able to evolve from semester to semester in what you're teaching the students. And you are able to develop advocacy projects that I really had no experience with, but I have been able to gain that experience through this amazing opportunity to direct a securities clinic. And I think it's been a huge opportunity for our students as well. Not only just the comment letters that other panelists have already talked about, but they actually meet with legislators to advocate for the passage of laws that are in the interest of investor protection.
Thank you, Scott. All right, Janine, every one of you professors are amazing advocates, but how do you advocate to school administration at your law school that you should start up a securities arbitration clinic at your school?
Well, I think the first thing that I would say, and by the way, I'm Janine Marichulo. I run the Securities Arbitration Clinic at Pace, and this is my first year teaching the clinic. I've been a practicing lawyer for 34 years, and I can first say there's tremendous support among this group. And I know because I just joined it, and I've gotten tons of support. But what I would say in terms of if I was going into an administrator to talk about why they should start a clinic, the first thing I would say is there's a tremendous need for this clinic. And the need is both within the community outside the law school and within the law school. In terms of the need outside the law school, we get probably about 5 inquiries from investors a week, but a lot of them are from out of New York State. And as Robert's going to talk to you about, that raises a problem, because in our clinic we can only represent people where there's a connection to New York. So we turn down a lot of people. So if you're a law school outside New York, your state probably needs one of these clinics. That's the first thing. The second thing is, and it goes back to what I said before, don't be afraid. Securities arbitration clinics aren't scary. I practiced law for 13 years when I first went to NASD, which was the forerunner for FINRA. I didn't take securities, and I didn't like taking corporations. But I bought the Securities Nutshell the weekend before I started, and I read it, and that was good enough. And I just spoke to first-year law students about applying for the clinic last week, and I told them, this is great. If you want to litigate, no matter what you want to do, this is a great clinic for you, because you're going to put all your your first year doctrinal practices into work. You're going to have contract claims. You're going to have tort claims, breach of fiduciary duty, fraud, and you'll have to look at evidence. But the other thing is, too, you'll learn about arbitration, and this is really, really important. I asked the students, who knows what an arbitration is? Nobody knew. Arbitration is the wave of the future. It's how disputes are going to be resolved. If you want your students prepared to practice, they should know these things. And then the final thing, I'm going to give you a personal anecdote. My first interaction with the clinic was a phone call I got from Paul Radvaney telling me that I made a mistake by not selecting one of his students to interview. Now, I wasn't looking for a first-year law student, and she had just graduated from law school. I was looking for a fourth or fifth year because that's what I needed for my practice. But Paul said such great things about her, and I worked at the U.S. Attorney's Office the entire time I was in law school, so I interviewed her. She was so well prepared to practice. She understood so much. And that's the greatest benefit, and that's what I think law students should do, is prepare their students to practice. And this is the greatest way to help your students understand how to take all their doctrinal learning and put it into practice. And that's going to prepare them to succeed. And as Bruce said, that's what you want. You want a successful base of alumni because they're going to support your school. So that's what I would say.
Thank you, Janine. So, Bob, most states don't have securities arbitration clinics. What are the challenges in multi-state clinic representation, sort of along the lines that Janine just mentioned?
Thanks, Rick, and thanks for that question. And I should say at the outset that I don't necessarily represent the views of all of the clinics, but from the Cornell perspective, this is a very important question because the simple fact is we would like to, and we have the capacity to represent far more investors than we represent, but we're limited to representing clients in New York State. So as you probably all know, there are two basic roadblocks to multi-jurisdictional practice. One is, of course, the general rule that lawyers can't practice in states where they're not admitted. And the second one is that states impose restrictions on the representations that law students can provide. But I think that these roadblocks can be removed. We already have the ABA model rule of professional conduct. It's 5.5C3, and as you may know, it says that a lawyer admitted in one state can represent a client in arbitration in another state if the services are reasonably related to the lawyer's practice. And private practice lawyers rely on that rule all the time. They regularly represent clients in FINRA cases throughout the nation. So as things now stand, private investor lawyers can take cases all over the country, but clinics who can't, for obvious reasons, risk violating any ethical rules, they can't. Even though, as Elizabeth says, the quality of clinical representations is typically outstanding. So that second roadblock to multi-jurisdictional practice are the rules requiring law students to be supervised by a lawyer who's admitted in the state where the action is taking place. And so unless the clinic has professors admitted in that state, students can't represent client under the present rules. So what can be done? I think we first look to FINRA, because FINRA enacted Rule 12208, and that says that a party can be represented by an attorney who has been admitted in any state or the District of Columbia. And in fact, FINRA's present rule, and I don't think it's changed, is that non-lawyers can also represent clients under most circumstances. So the FINRA rule, standing alone, already permits students to represent clients in FINRA arbitrations anywhere in the country, so long as state law doesn't prohibit it. So I think we could build on that FINRA rule. We can look to the ABA, we could look to the states to amend Rule 5.5 to allow clinics to represent clients in FINRA cases with restrictions. And the first restriction that I think would make some sense is that the case doesn't request damages over a certain dollar amount. And the second, of course, is that the student would have to be supervised by an attorney admitted in some jurisdiction. And regarding the dollar limit, I think $50,000 is a great place to start because from Rule 2012, FINRA Rule 12800, we know that the default for those cases, those under $50,000 cases, is that they are decided on the papers. And those cases that aren't decided on the papers are decided in an abbreviated procedure by Zoom. So most of these cases involve situations where the students never even enter into the jurisdiction of the other state. So anyway, I know this maybe is a little bit of a pipe dream. It's hard to make change, but I think those changes make a lot of sense, and maybe someday we'll get them.
Sam, you had a quick follow-up?
Yeah, just quickly, at our clinic, because we do have a very broad rule from the Illinois Supreme Court, we do handle cases all over. And except, of course, where there are other clinics where we refer it to them, but we do have that ability, and I think sometimes the rules restriction needs to be done at the state level. And it shouldn't be all that hard to get it lifted, to be honest. I think it's part of it's just bringing it to the attention and explaining it to the regulators, and my hunch is they'd probably be willing to do it, especially given that without us, people go unrepresented.
Nicole, I'm going to call on you for, what is the call to action? We had this meeting today. If someone's interested in going to their administration and saying, we should do this, tell us about who they should contact, what they should do.
Contact any one of us. We are all happy to help. We're happy to talk hours and hours. We all had a 3-minute time limit on our questions from Rick, and there's a reason for that. That reason is all of us could talk for hours about what we think is the best possible clinic experience that can be provided to a law student, bar none. And this is from someone who's been in other clinics as a student. I loved my clinical experiences in law school, but I don't think there's any other clinic model that brings a range of experience. So come and talk to us. We'll help you build the case. We can talk to you about the finances too. We've got folks with experience as directors of clinical programs and working with their deans and vice deans to find funding and things of the like. We know how to structure these, and we have good ideas on which ones continue, how to create a clinic that keeps going, and ensure that students who want this opportunity, and let me tell you, there's no shortage, get it.
Thank you, Nicole. Well, I'm going to take this opportunity. Of course, I'm going to thank the panelists for being panelists, but I also want to thank them for the amazing work they do in running these arbitration clinics. So thank you to the panel, and if you're interested out there in the audience and in the web audience, please contact
Rick. Can I have 15,
yes.
15 seconds?
Sure.
So my question was, what do I wish I knew when I started a securities clinic? I wish I knew how rewarding it would be. I thought that I would take this job from a law firm and I would be there a year and a half, 2 years, and I'm going to be there the rest of my life. It is the best job I ever had. It's the best job that I can imagine. And so I think that goes for probably most of the panelists here, and it's a wonderful position to be in.
With that, we are complete. Thank you so much.
Good afternoon, and welcome to the 2024 Investor Advocacy Clinic Summit. It's great to be here with you in person at the Securities and Exchange Commission today. My name is Stacy Pente, and I serve as the SEC Ombuds. It's also my privilege to be your host for this event, so please let me know how I can make your experience a more enjoyable one. Before I begin, I offer this standard SEC disclaimer regarding my remarks as Commission Ombuds and the remarks of my SEC colleagues. Our remarks today are in our official capacities. They do not necessarily reflect the views of the Commission, the Commissioners, or other SEC staff. About 8 months ago, I was in a conference room at Fordham Law School with the clinic professors here today and other colleagues from financial regulators. Each year, this group convenes at Fordham to learn about problematic practices and products that harm investors and to consider the difficulties that clinics face representing investors in securities arbitrations. So last June, we asked a question that we ask every year. What is the greatest challenge for clinics today? That time, however, each professor had the identical response. There are not enough investor advocacy clinics in the United States to meet investors' needs for free legal representation. The professors' stories illustrated this point. Investors from California, from Texas, from areas rural and urban had been defrauded, suffered significant financial loss, and called their clinics for help. But typically they couldn't help. Their own clinic resources were strained, and many were precluded from representing out-of-state clients. There are currently no investor advocacy clinics located west of Chicago, leaving a majority of the U.S. investor population without access to the specialized services that these students provide. At one point, there were as many as 25 clinics in the U.S., but the trend of clinic closures continues. At last year's summit, there were 11 participating clinics. This year, there are 10. These professors asked for our help, and so we listened. We're here today as a result to express our gratitude to these talented students dedicated to improving others' lives and to shine a light on the need to help those who are most impacted by financial loss. It is time to address this need. During today's summit, we'll learn from law students at Fordham, Northwestern, St. John's, Cardozo, University of Pittsburgh, and Howard University about their experiences and challenges representing investors in securities industry arbitrations. We'll listen to law students from Cornell and the University of Miami discuss their efforts to help educate and connect with investors in underserved communities. Law students from Pace and Seton Hall will discuss the importance of diversity, equity, inclusion, and accessibility in their daily clinic work. And our keynote speaker will share her perspectives along with the perspectives of SEC division directors, commissioners, and others. I'd like to thank the Ombuds team, the Office of Investor Education and Advocacy, and the Office of Minority and Women Inclusion for their thoughtful collaboration and commitment to this event. I'd like to thank Cristina Martin-Firvida, the SEC's investor advocate, whose unwavering support for our Ombuds work helped pave the way for this event and other advancements for investor protection. And I'd like to thank the Honorable Gary Gensler, SEC Chair, for his important contributions to the summit and his investment in the issues we will address today. Gary Gensler was nominated by President Joseph R. Biden to serve as SEC Chair on February 3, 2021. He was sworn into office on April 17, 2021. Chair Gensler has held many roles, notably Professor of the Practice of Global Economics and Management at the MIT Sloan School of Management. He's previously also served as Chair of the Maryland Financial Consumer Protection Commission and the Chair of the U.S. Commodity Futures Trading Commission. His commitment to public service, to the betterment of our markets, and to the financial security of American investors have been the hallmark of his tenure here. Chair Gensler, thank you for joining us.
Stacy, thank you so much. You're ever too kind, though. I'm just a guy who's blessed to be part of a great 5,000-person team and honored by a number of presidents to serve this nation, but I love public service. It's good to be with all the students and the faculty that are signing up. As Stacy said, each of us are speaking, in my case, as chair of the SEC, as others will speak to you in our official capacities, and I'm not speaking on behalf of my fellow commissioners or the staff. You can see we've been well lawyered that we all say this. I want to give a special warm hello to those in the audience who have made the time to participate in the advocacy clinics here. Welcome to Cardozo, Cornell, Fordham, Howard, Northwestern, Pace, Seton Hall, St. John's, University of Miami, and the University of Pittsburgh Law School students and professors. I think this is our 5th Investor Advocacy Clinic Summit, and it features a great set of presentations and panels, including some of the clinic work experiences and community outreach, and of course engagement with your communities, but particularly with underrepresented individuals, the role that diversity, equity, inclusion, accessibility has played within the clinic work. It's said that we have a 3-part mission here at the SEC, but one of those pillars is William O. Douglas, who then later went on to be a Supreme Court justice, but he was actually the 3rd chair. So I'm honored to be the 33rd chair. But William O. Douglas said that we're the investor's advocate. You see, he was saying the broker-dealers had their advocates, the exchanges had their advocates, the issuers had their advocates, but we're the investor's advocate. And it's the first pillar of our 3-part mission. Fundamental is the need to help all investors guard against financial fraud, and registrants have to comply with investor protection. That's the issuers, people getting money from the public to fund their ideas. But of course, we have parts of our law that relates to fiduciary duty, duty of care, duty of loyalty, best execution, and best interest, things that those of you who study securities law have become familiar with. The law school clinics, those that are participating here in the summit, of course, have important work to do in your communities, but also partners in our work. Just a little bit of history. One of my predecessors, Arthur Levitt, he's actually the longest serving chair in SEC history. He was chair for about 7.5 years during the President Clinton's term. But back in 1997, Arthur announced an initiative to give small investors an avenue to find excellent legal representation. At the time, Chair Levitt actually stated that, quote, small investors get much needed legal assistance and students gain valuable leading experience. So, it's kind of this win-win proposition. Much needed legal assistance that might not otherwise being met, and students getting a taste of the securities law, but also a taste of that connection with clients. And I think to date, the clinics, like the ones that you're all involved with, have really done an important thing. And you formally represented hundreds and hundreds of investors and recovered literally millions of dollars on their behalf. And I think that this summit affirms what Arthur Levitt understood so well. For investor advocacy clinics like yours, your wholesale involvement really does help our agency protect investors. It's like a force multiplier in a sense. Beyond your important work representing small investors who have experienced fraud, we value your outreach engagement efforts as well. And I want to thank all of the clinic affiliated members of the audience for the work you do for your clients and for perspective you provide to our agency. Victims of fraud far too often are older adults. We move about 700 or 800 enforcement actions a year. You can sort of do the math. I'm sort of reading 10 to 30 cases a week. These action memos that come up from our dedicated enforcement staff, and all 5 commissioners get the same. And then we get together later in the week and we discuss them, we inquire about it with the staff, and then we vote in a closed commission meeting. And I would say it's all too often my weekend reading involves some fraud, whether it's affinity-based or older Americans, retired, others near it. And they've spent decades preparing and raising money and saving money for their nest egg, so to speak. We also are, accessing, and this is a change in the world that you're so living, but such a change in the world about financial services. We long ago digitized money. Money has been digital for decades, but financial services now are provided through robo-advisors and brokerage applications. And of course, there's the challenges in the cryptocurrency field. And it's a question of what next technology is coming along. I'm not here today to predict it, but these changes completely change some of the environment. And of course, we still need to protect the investing public regardless of what the technologies are. But the changes have created some new opportunities for scammers to confuse and defraud the public. Our Division of Enforcement, ultimately the cop on the beat. We also have a Division of Examination. Together, they're half of our agency. I said a bit about affinity fraud, when bad actors target identifiable groups such as veterans, ethnic communities, members of a certain profession, and other groups. Another area of challenge in these new technologies present is in relation to digital engagement practices, whether through predicting what each and every one of us might do. Somebody uses behavioral prompts to differentially market, differentially price, and try to get us to do something that maybe isn't in our own interest. And so in finance, it's really important to make sure that the investor is always coming first, not the robo-advisor, not the broker that's got that app there. So again, the SEC is here to help every American investor that deserve the safeguards of our time-tested securities laws. I want to thank our Office of the Ombuds. Stacy, thank you. Office of Minority and Women Inclusion, Office of Investor Education and Advocacy for pulling this summit together. But mostly, I just want to thank all the students and faculty that are here to contribute to this. And I want to turn it over. I think I'm supposed to turn it over to the first panel.
Thank you, Chair Gensler. Yes, it's time to turn it over now to the first panel of students from Fordham, Northwestern, and St. John's University Schools of Law. Thanks.
Good afternoon. My name is Danielle Spees, and I'm here with my colleague Andrew Sporkin. We work in the Office of the Investor Advocate, and we're happy to be here. This afternoon, law students from Fordham, Northwestern, and St. John's will discuss their experiences in their law school's investor advocacy clinics. And we'll first hear from Vinay Komarajiri from Fordham.
Thank you, Danielle, for that introduction, and thank you to the SEC for putting this event together. My co-presenter, Nicole, couldn't be here today, and I know she regrets it, but I'll be taking over the presentation. Fordham has over a dozen in-house clinics, including the Securities Litigation and Arbitration Clinic. Under the supervision of Professor Paul Redvani, students have been working on FINRA arbitrations representing low-income investors that have lost their savings, usually essential retirement savings, due to misconduct of individual brokers. Professor Redvani, relying on his previous experience at a large law firm and as an assistant U.S. attorney, runs the clinic so that students are prepared for everything from the first interview all the way through an arbitration. So our clinic has two parts, a seminar portion and a casework portion, and each component is technically a separate class, but they work together to help students gain a deeper understanding of securities law and make us better advocates. So in the seminar, students learn the substantive law and procedure of FINRA and securities law in a classroom setting. Students also learn from each other through case rounds, just describing their individual work. Students practice doing openings, closings, direct and cross-examinations. And they even get the chance to do a mock arbitration in front of actual arbitrators at the end of the semester. Feedback is an important part of the seminar. Professor Redvani, as well as the other students in the clinic, give regular feedback on assignments and presentations. And finally, reflection is a key portion of the seminar. In addition to completing a mid-semester and end-of-semester reflection, students are encouraged to reflect on their experience and performance throughout the semester, as well as how FINRA can improve the dispute resolution process. So that's an added benefit. The other side of the clinic is obviously the casework, and the engine of the casework portion are really our team meetings. All of our teams meet weekly with our professor to discuss the progress made and allocate new responsibilities. Based on his teaching a Leadership for Lawyers class and a scholarship on leadership, Professor Radvani has developed a shared leadership model. Teams ranging from 2 to as many as 5 students, if we're doing a 5-day arbitration, will share the responsibility for leadership on a case. So shared leadership involves heavy collaboration. If a member of my amazing team is working on conducting the direct examination for the expert and I'm working on a summation, I'll ask my team member to help me develop the best arguments and closing because they're obviously more knowledgeable what the expert will say. The leadership role allows me a little more authority to request assistance from classmates who are obviously the same level as me, and we found that it improves collaboration. So the clinic has given me probably the most valuable lessons of any law school activity I've participated in, and this goes for a variety of factors. My ability to learn a new area of the law, basic financial concepts, improving my legal writing, and oral argument. So a huge benefit of this specific clinic is learning about capital markets and the regulations governing its many players. I had to quickly learn about various intricate financial products and the FINRA rules governing brokers who deal in them. And I would, on that note, want to thank the SEC for all your hard work on Regulation Best Interest, Reg BI. That was a fascinating development for us clinics. The cases we work on are wonderfully complex without being so abstruse that students can't really grasp them in one semester. The cases are complex not only because of the subject matter, but because they're not one-sided or slam dunks. Just want to clarify, do I have a little bit more time to keep going? Or? Yeah. Great, okay. In addition, although the financial products we deal with can be somewhat technical, FINRA rules are very easy to understand and apply. So that makes it easier for students to kind of take a really active role in working on the arbitrations. Throughout the semester, students are confronted with countless large and small decisions that we have to make as a team. This allows all students to improve their judgment and decision-making abilities, and these are just not skills that you can fully learn in a law school classroom. We experienced this firsthand last semester during multiple settlement negotiation conferences. Students have to conduct a detailed analysis of the strengths and weaknesses of our case and then counsel our client on the pros and cons of settlement versus arbitration. The primary activity my partner and I worked on last semester was conducting discovery. So we saw the entire life cycle of the discovery process. We submitted detailed discovery requests, and our adversary objected to some of them, which led to us having what are called meet and confers to try and resolve the disputes. The meet and confers can go on for over an hour and can at times definitely get a little contentious. And while we were able to resolve many of the disputes, in the end we filed motions to compel for a few requests. And this was the highlight of last semester, really, was oral argument. Right, and we had oral arguments regarding these motions to compel with all of the respondents' counsel present and the chair of the arbitration panel. So this 2-hour oral argument allowed us to pull from the tools we had developed throughout the semester in the seminar, our various team meetings, which included mock oral arguments, and the numerous conversations we had had previously with opposing counsel. We had to effectively present the arguments we had spent weeks preparing, but also had to quickly think on the fly as the chairman asked questions and made decisions on requests as we were arguing them. So everybody on our team, and we really do have an amazing team that I'm happy to work with, they've had multiple internships, taken simulation classes, and participated on competition teams. And those are great, but nothing beats being in a clinic when learning how to be a lawyer. It just gives students a real sense of ownership, as we don't just assist on cases by researching a minor issue or site checking a memo. We work directly with clients, opposing counsel, and participate in every aspect of our arbitration. But the fact that our work is closely supervised by an experienced litigator and educator means students are encouraged to ask questions and reflect on what they do to get feedback. Being a part of the clinic has made us better advocates because arbitrations move faster than civil litigation. We spend a significant amount of our time focusing on fact investigation and case analysis, and it allows us to focus on arbitration prep. So we're really not afraid to take these cases to arbitration, which I love. The clinic recently conducted 2-day and 5-day arbitrations, and these are really easier for students to grasp because the rules of evidence don't apply, but otherwise arbitrations are very similar to trials. Like I said before, students do conduct all parts of an arbitration, including direct and cross-examinations, openings, and closings. Of course, our professor edits multiple drafts leading up to the arbitration, but again, this is something that many litigators don't get the chance to do until years in their career, which is, be the man in the arena, so to speak. Professor Radvani runs the clinic because he wants the students to acquire transferable skills. In his many years of teaching, only a handful of students have actually gone into this very specific field of securities arbitration. The majority initially go to law firms to litigate, but many have gone into public interest and government as well. And all the skills we learn in this clinic are applicable to litigation, but also transferable to transactional practice. So I guess you can tell, I can easily say that the clinic has been the most valuable experience I've had during law school. I can think of no other opportunity for a law student to test their skills in such a meaningful way. I believe law students are exceptional and capable of taking on these challenges, and like I said, there's simply no substitute for actual litigation when it comes to preparing new lawyers for their careers. So I hope to see these opportunities expanded, and I appreciate the opportunity to get to share our team's experience.
Thank you, Vinay. I have a question for you, though. What's the most challenging part of being in your clinic?
Yeah, I think the most challenging aspect for me, and I think a lot of our team members, is that you're dealing with real clients. Like, there are real stakes to the situation, and often it's difficult to gain a client's trust. So while at first they might be a little bit, apprehensive about having students take on their case, they see how hard we prepare and work, and how much our professor, supervises us, and they end up coming around to seeing that we can really benefit their situation. And I think other than that, the biggest challenge is probably the fear of going up against an actual attorney. So we have to, you're a student and you have to develop arguments to challenge the logic of a professional that's been doing this for a while. And as I mentioned, our various meet and confers and oral arguments, it's really you versus an attorney. And I haven't even passed the bar yet, but I feel like I have professional rivals now that have over time, they just maybe actually dislike me because I argue so forcefully. But it really helps students feel like they can be litigators, that they have the capacity to be a great lawyer, and sort of not shrink themselves when they're actually put in a situation where the stakes are high. So those are probably the biggest ones.
Thank you so much for that presentation.
Thank you.
We will now hear from Asa Spurlock and Yohei Fujita from the Northwestern School of Law.
Thank you. My name is Asa Spurlock. I'm a 3L at Northwestern, and this is my second semester working with the Blum Legal Clinic's Complex Civil Litigation and Investor Protection Program with Professor Sam Tenenbaum.
And I'm Yohei Fujita, a tax LLM student at Northwestern Law, also with Clinic and Professor Sam Tenenbaum. Next slide, please. At Northwestern Investors Protection Clinic, we advocate for underrepresented investors, merging legal skills and financial analysis to recover millions. Our student-driven efforts offer hands-on litigation experience and foster a dedication to justice. Our impact enhances legal education and significantly benefits our clients, creating a legacy of excellence and empathy.
So one of the major cases that our clinic has handled or assisted on was the MF Global bankruptcy. And we represented a class of around 10,000 securities customers and ultimately helped secure a settlement for over 90 cents on the dollar for that class. Another more recent case involved the Block 1 cryptocurrency fraud, and we were part of the lead counsel team, and there's currently a settlement pending for multi-millions.
Most of our cases don't involve millions of dollars, but amounts that represent life-altering amounts to the individual. One case includes our representation of an individual client in an investment fraud scheme who lost $30,000, essentially their non-pension net worth. Here, the broker induced the client to make a real estate investment when in fact the broker used those funds to pay back his own child support. In another matter, a different case our clinic tackled was an annuity twisting case, addressing a situation where an advisor improperly sold a guarantee return annuity, opting instead to invest in a riskier variable annuity without proper transfer. Next slide, please.
So beyond these more major cases, each of us students at the clinic handle individual, more traditional investor protection cases where the clients have often lost devastating amounts of money. I'm working on two currently. One where a client received unsuitable advice about how to transfer assets from one account to another, and as a result of this bad advice from an advisor, incurred a large tax liability that could have otherwise been avoided. And in another case, I'm currently looking into a client or a broker for a client executed an unauthorized trade on margin, and this wasn't discovered for months. And when the client finally did discover, the broker effectively tried to cover it up. And so I'm currently trying to work through the account statements and correspondences and phone calls with the broker to try and figure out exactly how much money was actually lost.
The clinic contribution also involved representing a client victimized by a Ponzi scheme, successfully recovering $60,000. In collaboration with the U.S. Attorney's Office, they secured guilty pleas from the perpetrators and are actively pursuing litigation to reclaim the lost funds. In a different matter, our team represented over 40 African American homeowners impacted by a reverse mortgage fraud scheme, leading to a loss of over $10 million in home equity. This case has taken us through bankruptcy court proceedings in a $10 billion lender bankruptcy case, as well as working with the U.S. Attorney's Office to obtain guilty pleas from the wrongdoers, and conducting civil litigation to undo the effects of the fraudulent reverse mortgages. Next slide, please.
So in addition to the clinic's primary mission to help elderly and low-income investors who otherwise lack the means to hire an attorney to advocate on their behalf, the clinic is also a very special opportunity for law students that is otherwise not a part of the law school curriculum. Students that join the clinic's mission are placed in a position of being the primary point of contact with the clinic's clients. And that relationship often begins at the start of that relationship with the client, at the intake process. And that process can take many forms, but it often begins with a quick voicemail message or a cryptic email from an investor looking for help. And then it is the responsibility of us students to go and follow up and to investigate and to figure out the facts and to piece them together. And this process of disentangling what exactly happened is a back and forth with the client that is unique, I think, to the clinic experience. Law school classes, generally, they feed you the facts and the controversy. And in the clinic, it's very different. You are tasked with figuring out those issues yourself and determining whether there even is a case to begin with. And so, in my experience, this has been a tremendous exercise in learning how to ask the right questions, because oftentimes the clients themselves don't know what happened or how much money they really lost. And if it turns out that, in fact, this case is something that the clinic can handle, that student who handled the intake is in a great position to carry that case forward for the time that they're with the clinic. Next slide, please.
The Blum Legal Clinic's Investor Protection Clinic offers an unparalleled opportunity for law students to develop a comprehensive set of legal skills critical for their future careers. Students conduct in-depth legal research to support case strategies and learn to navigate legal databases and resources efficiently. Students develop essential communication and interpersonal skills as they learn to build trust with clients, understand their needs and concerns, and communicate complex legal information in an accessible manner. Furthermore, the clinic provides students with the responsibility of managing multiple cases simultaneously, teaching us how to prioritize tasks, meet deadlines, and manage our time effectively. Students are also exposed to ethical considerations, where they learn to navigate conflicts of interest, maintain client confidentiality, and uphold the integrity of the legal profession. Through participation in settlement negotiations and arbitration trials, students hone their negotiation skills and learn effective advocacy techniques. The clinic's immersive environment allows students to apply their legal knowledge in real-world settings, providing an invaluable bridge between theoretical study and practical applications. Next slide, please.
Yeah, so thank you for listening. We're happy to take a couple questions.
Thank you so much for your presentation. Asa, what has been your most gratifying experience participating in the clinic?
Yeah, so hearing a client's story, it's immediately apparent just how much trust they're placing in you, and Vinay alluded to this as well. They've often lost a life-altering amount of money, and as a result, because they placed their trust in someone they thought had their best interests. And now you, as a law student, are in a similar position of trust. And even as, as a student, you're acting as their attorney. And so in my experience, that trust and responsibility has been incredibly gratifying and motivating.
Would you recommend to other law students that they participate in an investor advocacy clinic? And if so, what would you tell them?
I would recommend, without reservation, to any student seeking real-world, meaningful experience to participate in an investor advocacy clinic. This is an opportunity to put your legal education to use while still a student, and at the same time add value to your community, to those who are underrepresented and underserved. My situation is an example of those benefits. I'm a tax LLM student and already have my law degree, but I plan to specialize in tax litigation. And the type of work the clinic does in financial fraud, working with a variety of financial instruments, and learning litigation skills is going to be especially helpful in my legal career.
Thank you so much. Now we're going to hear from Camille Purbost and Elizabeth Alhusen from St. John's University School of Law.
Thank you for having us here today and for all the other speakers who spoke before me. So Elizabeth and I are going to talk a little bit about the things that we did in the clinic last semester. Specifically, we had a client that we worked for the entirety of the semester, and we worked for the entire life cycle of the case. So we started with this client and we were able to wrap everything up before we moved on to the next semester, which was great. A bit of background about our client, without getting too much into the details. She was a single mom, not a lot of background in financial literacy, didn't know much about investor education, but she was very concerned about having a retirement account at her age, which she didn't have. So she hired a broker, naturally, and hired this person to create and manage her traditional IRA account. So that's what they did. They did that for a few years, and then the pandemic hit. She lost her job, and she asked her broker to put this IRA into cash. And then a few weeks later, she got a new job, and she wanted him to reinvest it again. But he never ended up doing that. And she didn't realize it for a year that her IRA was not being invested in. And when the market rebounded because of the pandemic, she wasn't able to benefit from that rebound. And she believed that she was paying maintenance fees on these accounts during the entire time that it was in cash. And this is someone who doesn't have very much money, so it was very important to her that she be invested and that she wasn't paying for nothing, essentially. So that's all we knew going into this case. And when Lizzie and I started the semester, all we had was her intake form. We had some of her emails with her broker, and we had some account statements, but not all. So the very first thing that we did was send her a document list. We met her on the phone, and we started speaking to our professors about highlighting some key issues with her case before we started an official interview with her. We scheduled this interview, we went through this interview, and it ended up taking 2 sessions to be able to get all of the information that we needed, because there was just so much context, background about her relationship with the broker and everything that had happened. So once we were able to speak with her, we got the whole story, we got all the documents, we got all of her account statements from every single month that she was with this broker, and we started getting to work. We did an account analysis, so we compared her account statements and the investments that she was in before going into cash to what she would have gained if she had remained invested in those investments. And we learned that she would have actually lost money if she had remained in those investments. And we also compared her accounts to if she had just been in the market generally, and we learned that she would have also lost money. Even though these comparisons were very speculative, it was great to be able to see that she didn't actually lose from her broker's mistake of not putting her money back into the market. So with this, and with looking through all of her account statements, we also saw that he wasn't charging her any maintenance fees during that time. So she had just not been reading her account statements properly. So we scheduled a counseling session, and we broke down all of this information for her. We broke down how we did the account analysis, what numbers we ran, how we ran them, and we explained to her everything that we did and how there weren't any maintenance fees on top of it all. And at the end, she was incredibly thankful. This was someone who couldn't afford to have a lawyer for herself. This was a small case. She wasn't able to find a lawyer in the first place. And we were able to help her find the representation to give her the answers that she was looking for. Because this was someone who wasn't even sure if she wanted to pursue this. She felt silly for not realizing that it had been a year before her investments, or that her IRA wasn't being invested in. And we were able to give those answers to her. So this was really rewarding for us. We learned a lot, and we explained to her that even though might not have been the outcome she was expecting, it wasn't all for nothing. And she left our clinic very happy, I think, with our representation, and we were able to bridge that gap in the market. So now I'm going to pass it on to Lizzie to talk about some of the other things that we did throughout our semester.
Yes, thank you, Camille. Working with our client was an amazing experience. However, we're not able to help every client that reaches out to us for assistance. Even if we can't take every case, we're able to engage in meaningful advocacy efforts that can help protect vulnerable small investors more broadly. For example, this past semester, Camille and I had the opportunity to draft a comment letter to the SEC in regards to a FINRA rule proposal. FINRA proposed amendments to their codes of arbitration and mediation procedure. In essence, the amendments focused on disallowing compensated non-attorney representatives, also known as NARs, from representing clients in FINRA's dispute resolution services. This proposal was aimed at curtailing the ongoing predatory practices that compensated NARs tend to engage in, including aggressive solicitation, non-refundable fees, and the unauthorized practice of law. The clinic supported these proposed amendments. We agreed that it is appropriate to prohibit NARs in the FINRA DRS forums, as NARs are not upheld to the same licensing requirements and ethical standards as attorneys are. Thus, this left clients to potential incompetent representation with no appropriate method of recourse. The proposal also included a law student carve-out, stating that law school clinical programs are explicitly not included in the definition of NARs. Clearly, this was something very important to us. Clinics, such as the law school's Securities Arbitration Clinic, provide pro bono representation to investors who otherwise are unable to find an attorney due to the size of their claims or the uncertainty of collectability. Thus, we believe it is critical that law students in clinic programs remain capable to represent customers in the DRS forum to fill this gap in ethical representation. Additionally, the clinic supported FINRA's rule proposal to continue to permit the ability of uncompensated NARs, which are often friends and relatives of a small investor, to represent them in the DRS forum. As a result, we were thrilled to see that the SEC Division of Trading and Markets preliminarily approved the proposal. In addition to written initiatives, the clinic is also able to advocate for our client base with other direct contact with regulators. Last September, FINRA hosted the St. John's Clinic and 2 other clinics at their New York City office. There, we were able to discuss key issues and share valuable insight about the cases we work on and the clients that we help. The FINRA staff truly valued our feedback, as these clinics are some of the only voices advocating on behalf of vulnerable small investors. Moreover, we're grateful to be here today to share with the SEC a little bit more about what we do and the clients that we help. Overall, being a student attorney in the clinic has undoubtedly been the highlight of my law school experience. It was fantastic to see the success and impact of writing our comment letter and helping our client, and we're happy to have played even a small part in promoting a healthier regulatory environment.
Thank you for that presentation. Just a couple questions. What skills have you gained from participating in the Investor Advocacy Clinic that have prepared you for success as a future attorney?
Sure. So I learned a lot about client communication. Like I was saying, we met with our client, we had interviews, we had counseling sessions, but we also worked on our client communication with every letter that we sent her, every email that we sent her. And not only that, but all the intakes that we were doing at the same time as representing our client. We probably did 5 to 6 intakes throughout the semester, and every single phone call that we had with these people, it was different situations, different personalities, and through speaking with all types of people, we learned how to soothe very stressed out people in very different ways. And so I think that was an incredible an incredible lesson in how to speak to different types of clients in a way that you're still showing your personality so that they trust you, they know who you are, they're not this sort of like lawyer-client gap, and you can still speak to them in a professional and competent manner. And for me, that was really important going forward as an attorney, to be able to have that experience to do so.
Thank you so much. Elizabeth, has your participation in the Investor Advocacy Clinic impacted your career goals? And if so, how?
Yes, Danielle. Personally, it has inspired me to pursue a legal career in the securities field after graduation this May. In the clinic, we help clients through what may be the most significant financial issue of their lives, whether it's their retirement account or their lifelong investments. It's a true honor to be able to guide and advise them through a very complex legal process. In addition, I'm grateful to have gained perspective on the role of regulators and the importance they have in promoting and maintaining the integrity of the marketplace. So absolutely, it has impacted my career goals. Thank you.
Thank you so much.
Thank you all for participating in this panel and your thoughtful presentations. Thanks again to these students for their thought-provoking presentations. It's now my pleasure to introduce SEC Commissioner Hester Peirce. Commissioner Peirce was sworn in as a commissioner in January of 2018, and she is now in her second term. She received her BA in economics from Case Western Reserve University and her JD from Yale University. Prior to becoming a commissioner, she's had several jobs, including clerking for a federal judge, working at a law firm, working on the staff of the SEC, working on the staff of the Senate Banking, Housing, and Urban Affairs Committee, working at an economics think tank, and working as an adjunct professor at George Mason University Law School. Despite her extremely busy schedule, she recently took the time to sit down with our own Stacy Pente to answer some student questions.
I want to thank all of you for being here today, and I'm sorry that I can't be with you in person, but I wanted to welcome you to the SEC, and I hope that you have a wonderful day. The work that you do is so important, and I'm delighted when I see law school students who have expressed an interest in our markets, which I think are so important. And we want them to be a place where investors feel comfortable investing and where they feel that if they do have a problem, they have somewhere to go to get help. And I think that's a role that you all play. So thank you very much.
Given the advancements in AI, funds and investment services will likely employ AI-driven investment advice or robo-advisors in scale to serve smaller investors who traditionally have not been able to afford or qualify for an account executive. What approach is the SEC currently adopting to regulate this application of AI beyond the requisite risk disclosure?
Wesley, thanks for the question, and I think it's a great point that you make that robo-advice, using AI to serve investors, is a way to provide advice to investors who can't afford to pay as much. So it can be a really helpful and effective way for people without as much money to get investment advice. And frankly, people with more money may like this method as well. But I think there's a fair question to be asked about how we think about regulation in this context. And we do have rules already around so-called robo-advice. And there also has been, recently, there's been a proposal that we put out for comment around predictive data analytics, which ties to this issue as well. I had some concerns about that proposal, but I think in the context of the comments, we're getting some really interesting feedback on how we should think about this issue, how we should think about regulating this new technology in a way that protects investors but also doesn't preclude firms from using the technology to serve investors.
You've claimed that the federal government has dropped the regulatory ball on cryptocurrency regulation. Where could investor advocacy clinics fit into a new cryptocurrency regulatory scheme for protection of individual investors?
Thanks, Daniel. And I think investor advocacy clinics at law schools can really serve an important purpose, not only with respect to securities, traditional securities, but also with respect to crypto assets that are securities. And I think that we're looking now at, I hope, ways of clarifying the rules so that it's obvious which crypto assets fall within our jurisdiction and which ones don't. But as we clarify those rules, you all can be working to help investors who have been harmed in connection with crypto asset purchases. So I think that that's very consistent with the other work that you all do.
The global COVID-19 pandemic has significantly changed many aspects of our lives, including how individuals engage with the stock market. With the rise in retail investing and increased participation of non-traditional investors, what measures is the Commission taking to ensure novices have the necessary information to make informed choices?
The trend, I think, that developed during COVID of new people coming into the markets is generally a positive thing. One of the reasons that I came back to the SEC as a commissioner is because I believe in the power of the markets that we regulate, the power of these markets to transform people's lives, people coming in as investors, people also drawing funds from the capital markets to build their businesses. And so we want more Americans to be participating in the markets. But we also, of course, are concerned about new investors coming in and making choices that are not informed and coming in without the necessary skepticism and education. And so I think that's exactly what we need to do, is we need to be encouraging people whenever they come into the markets to come in with skepticism, to ask lots of questions, to get the financial education they need. And then, of course, we're on our end of the job. We are working on making sure that people have access to information. That's the core of what we do. We're not a merit regulator, we're a disclosure regulator, so we're always working on making sure that people have access to information about the companies that they're interested in buying, about the products and services that they're looking at using, and so that's the bread and butter of what we do.
Commissioner Peirce, you wrote in December 2020 that the current accredited investor standard may not be ideal because it equates wealth and income with sophistication, which are often not the same. Are there alternative measurements for sophistication that regulators should consider?
Thanks, Zachary. And I think that accredited investor definition has been one of the issues that I hear most about as a commissioner. People, when they find out that there are certain products that are only available to people who have a certain level of income or a certain level of wealth, they react very badly to that. And they say that doesn't seem like a very American concept. Products should be available to everyone. And so one of the things that we all have been thinking a lot about is what are ways that we could assess sophistication without looking at wealth or income? Could we, for example, look at whether someone has taken a couple of courses at a community college on investing, or whether someone has a particular educational background? We have opened the door a bit by saying that certain financial services professionals are able to qualify as accredited investors without looking at their wealth and income. But there certainly should be other ways for people to qualify. Some other people have suggested that maybe someone could offer a test to determine whether someone can invest. My preferred outcome would be to say that anyone is able to invest in the private markets, but you have to acknowledge that there are risks there, and we should have a warning so that people know what they're getting into, because ultimately people are best able to make decisions. They know their own facts and circumstances. But I think some of these other potential measures to qualify people as accredited have real promise, and so we'll see where that debate goes.
You recently mentioned at a meeting of the SEC Investor Advisory Committee that the best thing we can do for investors is to provide them with sound, basic financial education, a healthy dose of skepticism, and the confidence to ask questions. As our clinic focuses primarily on serving underprivileged or otherwise financially lay clients, we see the value in ensuring that members of the public have the knowledge to avoid being taken advantage of. Did you have any particular tactics, ideas, or programs in mind with which to promote financial education?
I certainly appreciate the work that the clinics do in not only in helping investors when something bad has happened, but also trying to prepare them to be better investors, to ask better questions, to know when to walk away or run away from something that's being offered to them. I think there are several things that we need to do. One is to start educating people much earlier. I would argue that even in elementary school, the first steps toward financial education should be happening, and that then should continue throughout junior high and high school. But I also think that we need to look at ways to make financial education more interesting, and I think that means using technology in ways that we haven't typically used it here at the SEC. I think we're starting to explore using new technologies and communicating with people where they are, instead of trying to have them read documents that are very dense and not very interesting to read. So I think it's just looking for those kinds of ways to meet people where they are with financial education. And there are lots of people who are doing a lot of great work on that. People in the private sector, people like you, people in industry as well. And I think we all need to work together on continuing to think about innovative ways to reach people.
How do other agencies or the Fed influence the SEC's decision-making process?
Patrick, that's a great question. We certainly have a lot of interactions with other financial regulators at the federal level and at the state level. And as we work on rules that have implications for other parts of the financial sector, we'll reach out. The staffs of the two agencies will talk quite a bit. I had some experience working on derivatives rulemaking, and a big part of that rulemaking was working with our colleagues at the Commodity Futures Trading Commission. We had a lot of good meetings, and throughout that process, we were going back to them and asking them. They had worked on a similar set of rules, but had finished it before we had, so we were able to benefit from the experiences that they had. And then there are also more formal interactions that go on through the Financial Stability Oversight Council. We work with our international counterparts as well through groups like IOSCO and the Financial Stability Board. So there's a lot of interaction on rules. And then if other agencies want to, they're able to comment on our rulemakings, and we can comment on their rulemakings. So there are a lot of different ways that we work with one another.
In light of the comprehensive new SPAC rules designed to address information asymmetries, misleading information, and conflicts of interest, how does the SEC plan to monitor and enforce compliance with these rules effectively?
That's a very timely question. I think that the SPAC rules sort of, I will say that I did not support the final iteration of the SPAC rules, but as you described, they're quite comprehensive, they're quite prescriptive, and I would argue that at the end of the day, they're likely to lead to there being few, if any, SPACs. And so that may be the answer to your question, which is that there won't be the need to do a lot of monitoring because I don't think we're going to see a lot of SPACs.
What was your position regarding cryptocurrencies, including Bitcoin, prior to the SEC granting approval of Bitcoin ETFs? Do you believe the approval of Bitcoin ETFs will be beneficial for investors, the U.S. securities markets, and the U.S. economy?
Another very timely question. So I have, for a long time now, actually since I started here at the SEC as a commissioner in 2018 and wrote my first dissent on a Bitcoin exchange-traded product denial in 2018. So I've been arguing that, of course, depending on facts and circumstances, that a product like this should have been able to be sold to investors much before now. And so I think it is a positive development in the sense that, like other similar products, investors should have the ability to buy the product if they want it, and so it should be able to be available to people. That is a different question from the question of whether it's a good product for investors in general or any particular investor. That's something that an investor has to decide for herself. And it really is not the place of the SEC to make that decision. I think I'll go back to the same theme that I've been coming back to, which is that investors need to think about their own circumstances. They need to ask lots of facts and lots of questions about the facts of a particular product and about how that fits within their portfolio. And ultimately, it's a decision that requires a lot of thought. We, again, try to make sure that the disclosure provides the information that people need so that they can make good decisions for themselves.
What are your top priorities for helping the SEC foster fair, efficient, and transparent securities markets?
Thanks, McKinley. A great question. I think one thing that we really need to work on at the SEC is doing a better job at allowing there to be innovation in the industry that we regulate. Innovation ultimately allows firms to think creatively about how to meet the needs of investors. And sometimes that requires us as a regulator to work with them to make sure that the disclosure about these new products and services is right. And that process can sometimes take a long time. So I think we need to keep an open mind here at the SEC. We need to obviously identify where there are issues under our statutes, but we also need to work with the firms so that they can get these products and services out the door so that investors ultimately can take advantage of new technologies in their financial lives the same way they do in other parts of their lives.
Now we'd like to welcome to the stage Qudsiya Shafiq from the Atlanta Regional Office, the Division of Examinations.
Thank you, Commissioner Pierce, for taking the time to share your views with us. And thank you, Stacy, for having me. My name is Qudsiya Shafiq, and I recently joined the SEC's Division of Exams. I'm honored to be here and share the law school experience that shaped my career into what it is today. I feel even more privileged because I also get to introduce to you the professor I credit for piquing my interest in this field and encouraging me to pursue it. About 8 years ago, right around this time, I came across the Investor Advocacy Clinic at my law school's experiential learning fair. I was a 1L at the time and didn't know a thing about securities or the Investor Advocacy Clinic. All I knew was that it combined my different interest areas, it looked intriguing, and the students and Professor Iannarone were very welcoming. So I signed up. Unbeknownst to me at the time, that day I changed my career trajectory from commercial real estate to securities law. Over the course of the next 2 years, I learned the basics of federal and state securities laws, the FINRA arbitration process, and how to draft and respond to statements of claim. I had the opportunity to hear from guest speakers from FINRA, the SEC, and securities attorneys about their experience and impact in the space. And most memorably, I spent a year in the clinic talking to investors that had been harmed, conducting intake, listening to their stories, evaluating their claims, and seeing if we had a strong enough case to move forward. When we were lucky, we were able to negotiate settlements with firms and get our clients their hard-earned money back. When we weren't so lucky, we had to break the news and tell investors we couldn't help them. This was incredibly difficult because we knew we were their last resort and they had nowhere else to turn. Law firms simply couldn't afford or found it profitable to take on their cases. And I had the opportunity to testify about the importance of securities clinics right here in DC in front of the SEC's Investor Advisory Committee. So how did these experiences impact my work and professional path? Well, I think it's safe to say that I wouldn't have even known about this practice area if it weren't for the clinic. And I don't think I would have been so moved or as passionate as I am about my work had I not seen firsthand how a seemingly responsible investor's life savings could be mismanaged at the hands of a so-called professional. When I first started off in private practice, I helped SEC and state-registered firms with a variety of legal, regulatory, and compliance issues. And my favorite was always compliance issues. I'd always volunteer to review fee billing because I knew that's where I'd find the first evidence of client harm. Or I'd offer to review complaints because I knew that was the first source of written documentation a firm would have noting their client's concerns. Or I'd review advertisements because I knew how the average person would interpret them and could be misled by them and certain statements. When I later went in-house, I was attuned to these concerns and thought about the average investor in everything I did. I'd ask myself questions like, are the disclosures I'm drafting going to be easily understood by all types of investors? Am I including enough information for investors to make educated and informed decisions about a product or a service or an enhancement? And have I thought about all the conflicts and risk an investor would want to know about before deciding whether to move forward with a product? And now that I'm at the commission, I get to do more of what I love by conducting exams with people alongside me who are just as passionate about protecting investors. So it's safe to say that I've kept those investors in mind, both the ones I was able to help and the ones that I wasn't able to help. And that I wouldn't have been able to do without the clinic. I feel more strongly than ever that law school clinics are vital to helping retail investors who would otherwise go unrepresented, and students who would otherwise not know about this career path. But I'm most grateful to Nicole, who throughout the clinic, no matter how difficult a case or client seemed to be, always provided encouragement and a path forward. That said, it's my pleasure today to introduce our guest speaker, and undoubtedly my favorite professor, whose professional accomplishments during her time as a practicing attorney and professor are too many to name, but I'll certainly try. Nicole Iannarone began her career in private practice, eventually becoming equity partner and deputy general counsel at Bondurant, Mixon, and Elmore. She then entered legal academia, teaching at Vanderbilt Law School, Mercer Law School, and now Drexel University's School of Law. She founded Georgia State University's College of Law's Investor Advocacy Clinic, for which I am very thankful. And throughout this time, she's remained a distinguished scholar whose work has been featured in a number of legal journals and publications. She's held many leadership roles and currently chairs the FINRA National Arbitration and Mediation Committee and is a member of the CFP Board of Standards Public Policy Council. And she continues to make a difference in the lives of her students and retail investors every day. Please join me in welcoming Professor Nicole Iannarone.
as I think we can all see, there are a lot of folks who believe a great deal about clinics, and we're going to continue to hear more about that today. I can't thank the Commission, the Office of the Investor Advocate, the Ombuds for focusing on such an incredibly crucial issue. America has a problem with lawyers. You probably didn't expect a law professor to say that. The problem is not that there are too few lawyers in this country. The problem is that there are a lot of lawyers for wealthy people, for big companies, those who can afford to pay for them. Regular people with civil legal problems, I'm not even going to talk about criminal legal problems, but just regular people with civil legal problems don't have nearly enough lawyers to help them. And when they don't have lawyers, those people are left alone to navigate complicated justice systems. You know who designs those systems? Lawyers. Who do they design them for? Other lawyers. The civil legal system is full of all sorts of technical jargon, and it's really hard for someone without legal training to navigate those forums. So when I tell people I've spent most of my academic career investigating, looking at investor justice, they usually raise an eyebrow at me. They look a little bit puzzled. Why in the world would I possibly care so much about justice for people who had money to invest in the first place? There's so many other pressing legal needs. Nearly half of people in this country don't have enough savings to cover 3 months of living expenses if they have a health problem, or if they lose a job, or some other financial exigency impacts their lives. There's a significant and ever-growing wealth gap in this country. If someone has money to invest, they start, and even when they lose that money, sometimes remain in a better position than most people in this country. I'm not here to tell you that providing investors with access to justice is the most important unmet legal need we have. And I am not here to tell you that we need to allocate scarce resources first to investors. So, what in the world do I want to tell you today? I want to talk about why investor justice matters. I want to share something about regular investors, what they face when something goes wrong after they have trusted, listened to the advice of a professional advisor. I want to tell you how I think we might be able to fix some of the problems that these investors face when they try to recover and something goes wrong. First, why do I care about investor justice? When an investor comes to any of us in this room and says, I think I need a lawyer, something went wrong in my brokerage account, they're surprised by 2 things. First, that they can't go to court. They are required by pretty much any brokerage account agreement to arbitrate. Where do they have to bring their case? They've got to bring it in a forum overseen by the Financial Industry Regulatory Authority. And this is a point when an investor says, wait a minute, not only can I not go to court, but I have to bring my case in a forum that's overseen by those people who might have messed up and hurt me. This is actually a feature of the system. It's not a bug, as they would say in programming terms. Back when stockbrokers brought the industry over to the United States from England, this country's founding, they brought with them the concept of arbitration. You see, there were certain securities transactions called, at that time, time contracts. We know them now as options contracts that courts just wouldn't enforce. So, If you want to instill trust in an industry selling you something like a time or an options contract, you need to have a way to enforce that, right? And if the courts aren't going to do it, we need to have our own private system. That's where securities arbitration started in the country. Lots has changed since the 1700s. But what hasn't changed is the fact that securities arbitration is meant to protect investors, and it's meant to build trust in the systems. If an investor wins in a securities arbitration case, the firm and the stockbroker have to pay the award if they want to keep working in the industry. That just doesn't happen in court. Trust is important. Asa at Northwestern told us so much about what it means to work with someone who has already been defrauded, what it's like to rebuild that trust. Protecting investors, ensuring that they have trust in our markets is crucial to the integrity of our securities markets. We heard Commissioner Peirce tell us about all the new investors that are coming into the stock markets. It started in 2020 when, I don't know, there was something happening. We're all at home. We decided that we might want to do something with our time and maybe we can invest on our own. Well, research has told us that these new investors are different than investors we've seen in the past. They have smaller account balances, they're younger, and they represent groups that we haven't traditionally seen in the markets in such number. They're staying in the markets, and they are also beginning to not run their accounts by themselves anymore, but to seek advice from professionals to really help them meet their goals. When something goes wrong for these investors, they move from a category of being able to make ends meet to not. When she was a student, Kutsia came to the SEC, as she mentioned just a few moments earlier, and shared her experiences working with real people. She said two things based on her client work that I can't say any better than she did 7 years ago. She shared that for one investor, recovery was the difference between being able to buy dog food and toilet paper. For another, the ability to purchase both their medication and pay for their mortgage. Investors don't just face monetary damages, though, when something goes wrong. Financial wrongdoing also has health implications for those who suffer. That's emotional health and their physical health. The ability to tell a story matters. Colleen at St. John's just told us about how an investor heard from an independent source that, you actually did okay when there was a mistake here. Telling your story to someone who's there to listen, like a clinic lawyer, helps with healing. And the fact that FINRA will suspend these brokers and firms who don't pay their awards means that these investors aren't going to need those other civil legal resources that are just far too scarce. They're not going to need to declare bankruptcy. They're not going to need to have some help staying in their apartment. Access to investor justice also has a deterrent effect. If investors have an effective channel for redress, it reduces incentives for advisors to push the envelope. It makes sure that conduct stays permissible and acceptable. So, what happens to regular people when something goes wrong with their stockbroker? I want to tell you stories of two investors. These are real stories. First one is a Florida woman who soon after suffering the loss of her parents and her job, hired a stockbroker to help her. She told her stockbroker, "I don't want to get rich. I want to ensure that what little I have left is going to be enough to sustain me for the rest of my life." She said, "I don't have experience in the stock markets," and she relied on the advice given by the stockbroker. When she went to access the funds, however, she learned that her savings weren't available. They weren't liquid. They were locked up in a complicated product called a non-traded REIT. On the other side of the country, a 69-year-old California man sought a stockbroker's advice to help him navigate retirement. His stockbroker sold him a similarly illiquid investment. So, at first blush, it seems like these investors have a lot in common. They both saved. They both sought out and relied upon expert advice. They both ended up in the same type of transaction, a non-traded REIT, both allegedly because the fee it generated for their stockbroker was so high. And both were allegedly not eligible for the investment that they were sold. Despite their shared characteristics, the ending to each investor's story is dramatically different. The Florida woman was able to recoup her investment. The California senior's assets remain locked in a non-traded REIT, and a regulatory filing I reviewed reports that he continues to work as a security guard at the age of 72. What explains the discrepancy? Geography. The Florida woman lives in one of the 6 remaining states where investors like her can get free advice for stockbroker misconduct. And she got that advice from one of the clinics in this room today. The University of Miami's Investor Rights Clinic helped her get her money back. California investors don't have that option, nor do investors in 44 other states. If the California senior had wanted to recover, he most likely would have had to represent himself. And that's what happens to investors every day who have what we call small claims. You heard the clinic directors say this morning that we handle cases in clinics of up to $100,000. That's small in the financial world, but it's not small to me. It's not small to my family, and I imagine that it's not small to most people sitting in this room. It's an awful lot of money to lose and not be able to get private legal help. I wanted to learn more about how these investors who went it alone were faring when they tried to navigate the arbitration system. So I looked at a feature of the FINRA Forum, which is all arbitration awards are public. I wanted to know if those awards could help me answer 2 questions. First, do we have more unrepresented investors at the small claims limit under $100,000? And second, does legal representation matter? Are lawyers making a difference for these clients? The answers I found are not shocking, but it's nice to be able to say something is empirically provable as opposed to just anecdotal. Yeah, there is an association between claim size and whether an investor has a lawyer or not. From 2015 to 2019, investors with claims over $100,000 whose cases were decided by an arbitrator had an attorney 87% of the time. What about claims below $100,000? Representation rate dropped to 49%. The need appears to be the strongest at the $50,000 mark, where more than half of all investors proceed without a lawyer. And as somebody who works in a law school, I was really happy to see that the answer to my second question is yes, lawyers do in fact make a difference. Having an attorney was associated with recovery. Let me tell you more about that as it relates to the smallest cases, $50,000 or less. Investors who went it alone won in less than a quarter of all of the cases that are brought. Let's compare that to other types of representation. NARS, Lizzie at St. John's told us a little bit about them earlier. They prevailed in this data set 27% of the time. How about the lawyers? They prevailed in 40% of the cases that they brought. Something really interesting happened when I looked deeper into the lawyer category and separated out clinic lawyers and non-clinic lawyers. Do you want to hazard a guess as to who did the best and had the highest rate of success in FINRA arbitration? After you've heard from these amazing students this morning and the ones that you're going to hear from this afternoon, I'm sure you won't be surprised that clinics have the highest recovery rate. Clinics recovered in 56% of cases that they brought from 2015 through 2019, and an arbitrator decided. Well done, clinics, and I think for that you deserve a round of applause. Why are we seeing so many more small claims investors? Why are they losing more cases? I can't answer those questions. The awards data don't give us quite enough to get there, although I'll tell you it's an awful lot more than any other arbitration forum gives. Nevertheless, there is some really strong suggestive evidence that pro se parties are having a really hard time finding a lawyer if their claim is smaller, and if they don't have a lawyer, they're not doing nearly as well. So let's turn back to the civil context that I started by talking about. There's some really important differences between consumers who represent themselves in civil courts and investors who do the same in arbitration. When you go to court, there's often resources at the courthouse. Maybe there's a patient judge who helps a pro se party by researching the law that applies to the case, a court clerk, a non-lawyer volunteer or other resources, even appointed counsel. Courts have taken some steps, not nearly enough, to eliminate asymmetries between self-represented claimants and represented parties. Unlike judges in civil court, however, arbitrators don't have to be an attorney. And interestingly, those that decide the smallest claim cases don't have ties to the securities industry, meaning they might not have knowledge of these complicated products that investors have been harmed by. Arbitrators are expressly prohibited from conducting any research into the law or facts of their case. And while this might be absolutely fine when you've got a lawyer on both sides of the case, I think it can be problematic when we have an arbitrator who doesn't know the law already, and we have a well-resourced, well-represented firm on the other side of the case. Clinics fix this imbalance. So, do I think we need more clinics? Yes, absolutely. The gold standard for solving this representation gap is to get more lawyers. And I think it's even better for investors when those lawyers happen to be affiliated with clinics. Chair Gensler talked about how, here at the SEC, Then Chair Levitt began law school clinics by issuing a call and saying, law schools, you can fix this problem. And as Chair Gensler said, it's a win-win. We're not just helping investors, but I'll tell you another secret. They benefit far more than investors. I'm absolutely floored by the fantastic presentations we've seen by students so far, but I'm not surprised because I've previously worked in a clinic. The skills that students gain in a clinic are absolutely remarkable, and I can't think of another type of practice area where you can gain all of those skills. Law schools benefit as well. Howard's director told us this morning about the great halo effect that the entire law school gets when the clinic does something great. I agree. And I'll tell you, if you talk to these clinic directors, ask them about how popular their clinics are. If there's a popularity contest, these clinics that nobody has ever heard of in an area of law that many students and professors didn't even know existed tend to be oversubscribed every single semester. I bet it's taken a couple of semesters for some of these students to actually get a spot in the clinic. They're coveted. And students with these skills get jobs. Lots of jobs. We clinic directors believe in our students and continue to, even after they've graduated. I still say we clinic directors because I'm one of them. There are lots of jobs. We support the clinics, the students. They've done so much. So I could talk all day. I need to stop. There's lots more that you're going to hear from many others, but I'll end with this. I'm so glad the SEC is focusing attention on this issue. It's been a long time coming, and we need to ensure that investors have better access to justice. Thank you for hosting this forum.
Good afternoon, everyone. I'm Christina Martin Fervita. I'm the investor advocate at the Securities and Exchange Commission. And it is my pleasure to introduce the next panel this afternoon, which will be moderated by my colleagues from the Office of Investor Education and Advocacy, with whom we are co-hosting the summit today, along with the Office of Minority and Women Inclusion. And we're very happy not only to be hosting you in person, but to be co-hosting with both of those offices, which play such an important role in our outreach engagement with retail investors. I'm also very happy to introduce this panel in particular on advocacy and outreach because as a person with a 25-year career in legislative and regulatory advocacy, I'm always very excited to hear from new advocates, new entrants in that career field. So please consider that you don't just have to be a traditional lawyer, you can also be sort of an off-road lawyer like I chose to be. I'm also very intrigued by this panel and the experiences they're about to share because I believe that the foundation of excellent advocacy is the ability to really understand the actual experiences that the clients you represent have. And the clinics provide a very unique opportunity for all the students here to do that. And it is something that we strive in the Office of the Investor Advocate to do every day, to really understand, engage with retail investors, and listen to them and the experiences that they're having as they participate in our capital markets. And finally, the last reason I'm very excited to introduce this panel is that the students who are sitting here right now come from the University of Miami Law School and Cornell Law School. And these two schools are particularly special for me because the students from the University of Miami Law School represent clients who live in a community that has many, many households that are like the household that I grew up in, where English is not the language spoken at home, where multiple generations live together, where immigrants essentially who have come to this country and consider doing what they want to do with the money they have to be a big part of the reason they came here. This school really has an opportunity to see a lot of those households. And of course, Cornell, for any of you who have seen my bio, is my alma mater and will always be a very, very special place in my heart. So go Big Red. And with that, the panel on the panel on advocacy and outreach. Thank you so much.
Well, thank you very much. Well, welcome everyone. Welcome to the second panel of our summit on outreach and advocacy. My name is Paul Solsky. I'm an attorney in our Office of Investor Education and Advocacy, and I'm joined by John Moses, the Deputy Director for our Office of Investor Education and Advocacy. So let's just get started. Mr. Hunt, can you give us a brief overview of the Cornell Securities Law Clinic?
Hi, yes I can, absolutely. Good afternoon, everyone. My name is Zachary Hunt, and with me on stage are Jade Lee and Jianing Zhao. And with us in the audience is Nicholas Hippis, who worked on today's presentation with us. We're all from Cornell Securities Law Clinic in Ithaca, New York, and we serve our community in several different ways, including public presentations about securities law and investment fraud. We also provide no-cost legal services to victims of securities fraud, including representation up to and including arbitration if necessary. And we also we're all very, very excited to be here today. So thank you again to the SEC for having us.
So great. So I think that the investor advocate was very equal in discussing the two schools, but maybe we can get a little rivalry going here. Since I'm sitting over here with you, Ms. Lennon, maybe you could tell us a little bit about the background for the Miami Law School Clinic.
Of course. Hi, my name is Marian Lennon. I am from the University of Miami Investor Rights Clinic. And just like other security clinics, the University of Miami Investor Rights Clinic is a not-for-profit organization that provides pro bono legal representation to investors with small claims who cannot obtain legal representation in disputes with their brokers. Our clinic additionally focuses on investor advocacy efforts and outreach in the interest of investor protection. And I think it's super important to note that our clinic is the only operating clinic in the southeast region of the United States, and we have been in operation since 2012. To date, we have recovered over $1.4 million for our clients.
That is really impressive. You do know the history and stats on your clinic. That's really great and impressive, especially following the keynote from the professor there. So thinking about advocacy, outside of client representation, where obviously they've done quite well, right? How do you advocate for investor rights?
Yeah, next slide, please. Thank you. So our clinic advocates for investor rights through legislative advocacy, which includes comment letters and direct meetings with legislators through Piaba Hill Day, which I'll go in a little more in depth in a moment. But as for comment letters, we have drafted more than 20 comment letters relating to SEC rulemaking and regulatory actions. Highlights of recent comment letters include responses to proposed revisions to NASA's statement of policy regarding real estate investment trusts, and notice of filing of a proposed rule change to amend the codes of arbitration procedure to modify the current process relating to expungement of customer dispute information. Additionally, SEC Chair Gary Gensler has quoted the clinic's comment letter during his during his remarks in 2021 during SEC Speaks, Chair Gensler referenced the clinic's comment letter relating to the use of new and emerging technologies by financial industry firms, and he discussed our finding of a sharp increase in clients and prospective clients who have suffered losses in their account with digital platforms that use DEPs, and discussed the clinic's view that these business models do present a conflict interest between the retail's investor needs and the digital platform's incentive to make money. Additionally, the clinic is very heavily involved with the Public Investor Arbitration Bar Association, and that's also referred to as PIABA. And PIABA is a nationwide association of lawyers who are representing investors. And PIABA also organizes an annual event called Hill Day, where attorneys meet with this congressional staff to advocate for investor protection legislation. The clinic has participated in several PIABA Hill Days over the years where we have directly advocated for investors. And this past June, the clinic met with offices of 7 lawmakers, including 2 senators and 5 representatives. Here, the clinic was advocating for investors related to mandatory arbitration, as some investors receive an award for damages after arbitration but cannot collect the monetary compensation due to the financial insolvency of some brokerage firms. Additionally, investors might abandon investment loss claims entirely because of the cost of proceeding in inexpensive non-FINRA arbitration forms like AAA and JAMS. Additionally, some investors cannot find legal representation at all. And to that point, we have advocated for support of a bill called the Investor Justice Act that would create funding mechanisms for securities clinics like ourselves.
Thank you very much. I think they threw down the gauntlet, actually.
All right, yeah, so since they did throw down that gauntlet, Ms. Lee, I believe, so Miami just discussed their process or their, involvement including in many things, many advocacy activities, including letters to the SEC as part of our rulemaking process. Can you discuss some of your activities? I believe you also are engaged in our SEC rulemaking.
Yeah, absolutely. So our clinic also really tries to participate in the SEC's rulemaking process by submitting a public comment letter. So when the SEC requests for a comment letter on SEC rule proposals or regulatory actions, our clinic picks on one of those topics, and a team of students would start working on drafting a comment letter, which takes weeks or sometimes months. And last year, I worked with a team of students and our clinic professor to write a comment letter on the amendments to the supplemental standards of ethical conducts for the SEC members and employees. So the SEC proposed 4 amendments, which included prohibiting certain types of investments that might pose a higher risk of conflict of interest, and also eliminating reporting requirements for certain type of investments with lower risk of conflict of interest. So in our comment letter, we tried to address whether the investments would actually pose a higher or lower risk of conflict of interest, and also try to discuss how the rules could efficiently allocate the resources within the SEC to promote the integrity of the SEC. And this was a great learning experience, and it was an exciting process to write a comment letter, and we also tried to really represent the underserved investors in our comment letters.
Well, that went right to my next question. I was going to ask how you see these comment letters serving the underserved community.
That's a great question, and I think we're basically trying to really give them a voice, because in a lot of cases, the underserved investors that our clinic really strives to represent are not really in the position to really file a comment letter on their own. They have very limited resources and time, so what we try to do is we really try to amplify their concerns in our comment letter. So for example, in our comment letter, we wrote that sometimes limitations on SEC employees and members' securities transactions are important, even though it may seem a bit harsh, because the integrity of the SEC really directly impacts the investors' confidence in the financial market.
Let's turn, I think we're already getting short on time, so let's turn to the topic of outreach. Mr. Hunt, can you describe some of your clinic's activities related to outreach?
Oh, yes, I can. Our outreach activities have impacted our community in many different ways, but two in particular that I'd like to highlight today are first, our outreach activities have been indispensable in putting our clinic on the radar for people who could benefit from its services. And we've even found that often, even just learning that our clinic exists can prompt some investors to pursue claims that they wouldn't otherwise. And second, by participating in public outreach, our clinic has been able to educate so many members of our community, particularly the elderly and retirees, about securities law and investment fraud. For example, last year, a group of us traveled to Syracuse, to a senior education center in Syracuse, to give a presentation about the warning signs of investment fraud and how to recognize dangerous financial products. And we even taught them how to use BrokerCheck. The audience was very enthusiastic, and we even had one attendee approach us afterward about a claim that she wanted to pursue. We even ended up staying longer than our scheduled time because our audience was eager to ask so many questions. So it was a really great experience for everyone involved.
That sounds outstanding. And from those of us who do this at a full-time basis, going out and talking to the community, we totally understand that idea of them sticking around and asking more questions. It's very really hard. It's really nice to have that kind of input or excitement from the community. Miami, how about you, Mr. Brunner? Actually, one maybe group of individuals I'm thinking of are potential investors I think of nowadays, as we heard earlier in our discussions, how so many more young people seem to be coming into the investment world, starting to invest, and with all the information they're seeing on social media and even celebrities and sports stars advertising it on TV, we're seeing a lot more of these young folks who maybe don't have the experience or the knowledge. Have you had any experience dealing with that group?
Yes, and thank you for your question. I apologize that my voice is a little hoarse. It must be the cold weather. But we, part of our clinic is we are, obligated to do an outreach project once each semester. And more recently, especially after COVID, our outreach efforts have been balanced between senior investors and young people. We've gone to high schools around the area. We've connected with college students in the area and beyond. And even boys and girls clubs to go and educate them and interact and let them know about what investing is, what to look out for, and really instill those good habits for them at a young age. And this is important from what we've discussed, because you do see through social media and the regular media and with gambling so prominent as it is now, the gamification of investing. And as someone who has siblings who are in high school and college age, it's fun for them, or maybe fun's not the right word, but impressive, or they're impressed on about seeing people who are able to make money or able to make these gains. And I know that, there's Reddit forums and other web pages where people are displaying like, oh, pay me for this access and I'll show you how to make money. And so we really wanted to reach out to young people in the area. And, as it's been mentioned, people who are first-generation Americans whose families work so hard, specifically in our community, to bring them to this opportunity and to give them security, to give them the knowledge of, this is how to best put yourself in a situation for your financial future and, instill good habits. And so it was really rewarding, the outreach that we've done to interact with young people and, just let them know what's out there and what resources are there and how they should, focus on good investing habits.
Thank you, Mr. Bruner. That's great. I see you're aligned with the commissioner during the Q&A with starting with young people even in school. But my preteen calls me a boomer. So let's talk about older investors for a second. I don't think he means this as a term of endearment. So let's talk about what you're doing for older investors. You mentioned boys and girls clubs and schools, but Mr. Lewin, what about older investors in South Florida?
Yeah, great question. So I'm gonna give you some background first. So according to the Population Reference Bureau, in Florida, we have the second highest population of 65-year-olds and older at 4.6 million individuals, and us being located in South Florida, it's a greater concentration. So majority of our clients here at the clinic in Miami are older individuals. And what we discuss with them are common investment types such as 401ks, annuities, bonds, how to spot potential Ponzi schemes, common scams, and new scams that are coming onto the market, because they may not be aware of how dangerous some of these new scams are. And if we give them the tools to spot them in the first place, they know how to respond properly. We go over identity theft. Some of these new scams they're not really new scams, but they call, a scammer will call them saying, hey, I need your password to a bank account. They give them because they're very trusting in nature, and it's unfortunately, but they get all their money transferred out of their accounts. We also discuss misleading investments and affinity fraud, which is basically where an individual poses as a member of a community, gains the trust of that community, and then financially exploits with them. That's also a big issue in South Florida, for example, where a person will pretend to be a member of a church, gain the trust of the congregation of the church, and then financially exploit them. And then the clinic, we go to senior citizen homes, assisted living facilities, where we present all this information to them. And then when we have students in the clinic that speak multiple languages, we do those presentations and PowerPoints in that language. So we've done them in Spanish and French Creole. So like, why is this all important? I think that's a really big point that we need to hit, is that the individuals that we represent, especially older ones, they've worked for the money that they've earned. They're living off of this money. They have nothing else. And the tools that we give them empower them to make proper decisions. So when a financial advisor or broker comes to them and the advisor is pushing a very aggressive product, they have the tools and knowledge to say, no, this is not a suitable investment for me. This is not my best interest. And also, like, older people are a lot more trusting. They potentially may have declining cognitive abilities to make the proper decisions, and being able to educate them and make sure that they're safe is really important. And also with AI becoming a lot more popular, a new scam is coming about where they use AI to copy a loved one's voice, and then the scammer will call the older individual and pretend to be their loved one with the actual voice, and they'll be saying then they'll get their account information and steal their money. And just recently, in this week, we took an intake where an individual was called by a scammer pretending to be their bank, and the scammer needed his password, and unfortunately that person gave his credentials to the scammer and got the money out of his account. So this is a very important topic, especially what we deal with here at the clinic.
Thanks a lot.
Well, we are unfortunately running out of time, so I want to make sure we get to everyone. So, Ms. Zhao, are there any experiences with your work in the clinic that really stands out to you that you think is really worthwhile sharing with the audience?
Yes. So in our work, we do advocate for investors by conducting outreach to securities firms. For example, in one of the cases I worked on, the client, his pension distribution was received but delayed, and he didn't really understand why. After trying unsuccessfully to resolve it by himself, he reached out to us for help. And we reached out to the brokerage firm on behalf of the client requesting records and information. We were able to get them, read through them, and figure out what's going on and explain to the client why his payment was delayed. It turned out that there was a misunderstanding where the firm requested many documents from the client, but the client didn't exactly understand what he needed to provide or why. There was also a language barrier, which I was able to help bridge due to my Mandarin language background. So after we explained everything to the client, he was very thankful that we helped him gain a better understanding of the process, and this also helped avoid unnecessary arbitration.
Well, I'd like to follow up with that. Were there some cases where you weren't able to help, or maybe you had to decide not to pursue the case?
That's a good question. Thank you. Yes. So what I learned in the clinic is also that not all clients' concerns merit a lawyer's involvement, and that it's important to know when to not get involved with a case. For example, in one case that we encountered, the client had an issue that would potentially merit us reaching out to the firm, but we decided not to because the client, who is a sophisticated investor, had some inconsistencies in his story. He was unwilling to disclose some documents, which is a big red flag, and he also had unrealistic expectations of what he wanted our clinic to do. So not only do we not want to pursue potentially untrustworthy claims, we also want to maintain a professional, sustainable relationship with the firms, as well as help investors in general to develop more realistic expectations.
Very good. Outstanding. That's very interesting. Okay, let's just finish up. So back to you, Mr. Hunt. Let's just finish up with kind of, again, kind of promote, so let's be honest, promoting the benefits of these clinics, not just to the community, which we've been talking about this entire time, but also to the students and to the schools. What personally have you gotten out of being involved in the clinic?
Oh, yes, thank you for that. I think one of the most important benefits that I think all of us have felt from our time in the clinics is the exposure we've gotten to real-world legal work, including everything from interacting with clients and managing cases to even public speaking and advocacy. And these are the kinds of skills that are not only some of the most important for practicing lawyers, but also some of the most difficult to fully develop through just traditional law school coursework. For example, imagine if you were learning how to play golf, but all you did to learn was sit in a classroom talking about golf and reading about golf and thinking about golf, but the whole time you never set foot on a golf course. I mean, obviously that would be ridiculous, but for better or for worse, that's how most of law school is taught. And so for us, these clinical programs are really analogous to stepping out on the golf course, and in that way, they're one of the most rare and important opportunities we get in law school.
Thank you. In fact, that was outstanding. I'm going to steal that. I hope you don't mind that. For the rest of my life, when I explain law school, I'm going to be using that. So as you can see, these students are outstanding, and they all have great experiences and are really very outstanding in their presentations and discussing, and they could probably speak for the rest of the day on it. So please do stick around for the reception and grab them and talk to them about their experiences. But we're going to have to conclude this panel. So I just want to say thank you to everyone here, and thank you to everyone who joined.
Thank you to John and Paul and the students of Cornell and University of Miami. Good afternoon, everyone. I am Allison Wise, the Acting Director of the Office of Minority and Women Inclusion. And right now, it is my sincere pleasure to introduce SEC's Commissioner Jaime Lizarga. Commissioner Lizarga was sworn into office in July 2022 after being nominated by President Joe Biden and unanimously confirmed by the U.S. Senate. During his 3 decades in public service, Commissioner Lizarga has served as the Democratic staff of the House Financial Services Committee, advised congressional leaders, and head of executive federal agencies on policy and legislative matters, and served as senior advisor to the then House Speaker Nancy Pelosi. Commissioner Lizarga earned his bachelor's degree with high honor from the University of California, San Diego, and earned a master's degree from the Lyndon B. Johnson School of Public Affairs at the University of Texas. Because of his vast professional and academic experience, the commissioner is known as an expert in policy issues involving financial markets, small business, housing, international finance, and immigration. I welcome Commissioner Jaime Lizarga.
Thank you, Allison, for that lovely introduction. It's a pleasure to be with you here today at today's event. And I want to offer my sincere thanks to the law school students who are here in attendance today and the important work that you're doing in representing harmed retail investors. Many of these retail investors might not have had any recourse to seek justice without your help, so your work is absolutely essential. And as someone who has been in public service for as long as I have, I know how difficult it can be, but also how rewarding it is to help people who are harmed. And it's what really gives power to the work that we do in public service. So at its core, the SEC has a mission that is about in my view at least, it's really about the aspirations of all working families to attain a secure and more prosperous financial future with the confidence that their interests will always be protected. To me, that's a very deeply personal part of our mission, and it really dates back to my own personal experience growing up in a Southern California working class community, and also from my 3 decades of public service, as Allison just pointed out. So that has shaped my worldview about how I approach my work as commissioner, and again, also in the context of the work that you do through your clinic. So again, thank you. Thank you for being here. Thank you for the invitation to be here. I'm going to stop there, and I'm going to move to a few questions that several of you asked. We don't have enough time to answer all of your questions. You all offered some very insightful, thoughtful questions that I wish I had more time to answer. So we picked a handful of them that I'll go ahead and read and provide answers to each of them. So the first question is from Zachary Hunt, and he asks, Commissioner Lizarga, shortly after the collapse of FTX, you mentioned in a statement that, quote, problems in the digital asset market are worse than those in the traditional finance system because they occur in a largely unregulated space, end quote. What are some of the most important differences between digital asset markets and traditional markets that ordinary retail investors should be aware of? As we all know, trust and confidence are essential elements of our capital markets and their effective functioning. And the trust that investors and the confidence they want to have when they put their hard-earned money into the markets with the hopes of earning returns safely, also recognizing that they're taking a risk. Our federal securities laws provide important investor protections, and to the extent that any industry opts not to follow those laws as a choice, then I think the big downside of that is that investors are being denied the protections that provide that trust, that confidence that makes our markets the hallmark of the world. So when there are illegal, unregistered offerings or illegally unregistered intermediaries like broker-dealers, exchanges, clearing agencies, those investor protections just aren't there. I think the other key component of registering securities when digital securities are offered as securities and fall under the definition of the securities laws, if they are registered consistent with our laws, there are important protections that come with that. It helps investors understand the issuer's business, the financial condition of that business, manager's qualifications, the risk factors in the business, and without that information, investors are not able to make an informed investment decision. So I think it's very important for these protections to apply. The other advantage of registration by intermediaries is that it minimizes conflicts of interest. It ensures that orders that go through the market are handled fairly and transparently, and that investor assets are protected. Just to give you a couple of examples, for registered broker-dealers, there are certain requirements that are essential to a transparent market that works well. Record keeping and reporting, commission and SRO examination, rules regarding conflicts of interest, fraud, net capital, and consumer protection. Registered exchanges must have rules that prevent fraud and manipulation, that promote fair and just equitable principles of trade. promote just and equitable principles of trade, that ensure that there are no unreasonable fees and that there's no unfair discrimination between customers, issuers, brokers, and dealers. Registered clearing agencies are subject to rules that protect and segregate investor and customer assets. They manage risk. They provide fair and open access to their services and also manage conflicts of interest and ensure that they maintain sufficient capital. So these are all important protections that ensure that in a market that operates well, it generates the trust and confidence for investors to know that even if they're wrong, they have recourse. There's an ability for them to, first to evaluate the nature of their investment with as much information as possible, and to then seek recourse if they're wrong. So I'll stop there for that question and move on to the next one. The next question is from, I hope I'm pronouncing this correctly, my apologies if I'm not, Jianing Zhao, who asks, Commissioner Lizarga, recently you commented on the Disclosure Subcommittee's draft recommendations on the use of digital engagement practices by brokers and advisors, where you emphasize the importance of the protection of retail investors. I was wondering what you specifically think of the use of AI technologies and digital engagement practices. There have been a lot of claims on how AI can help companies decrease operation and compliance costs, help regulators evaluate filings and identify potential risks, et cetera. But how do you foresee the role of AI in the protection of retail investors and the interactions between companies and investors? Really, really good questions. AI is an emerging field. There is enormous potential benefit to AI, also downsides that we need to take a really, really close look at. Chair Gensler recently gave a speech where he highlighted some of those benefits, greater financial inclusion, and enhanced user experience. Some of the downsides also include the potential to monopolize the tech field because of economies of scale and network effects, possible consolidation among cloud providers. So that could lead to concentration risk and some broader systemic risk. So I think it's important for us to analyze these potential risks and assess the potential implications for how we oversee, for our markets and how we oversee those risks and any steps we may need to take to address them. There are questions about disclosure that on the part of market participants who use AI and the disclosure of material risks, and also the obligation that certain market participants have to investors on making recommendations potentially based on inaccurate information generated by AI models. So it raises some unique questions that we need to really think through, and I think it's important for us to not lose sight of the importance of assessing these implications. And these are questions that I'll continue to work with my colleagues on the Commission going forward, and also with Commission staff. So, but it also I think presents exciting opportunities for us to think about in terms of innovation and that kind of thing. So that takes care of that question. Let me move on to the next question. And that question is from Yohei Fujita, who asks, in light of the comprehensive new SPAC rules designed to address information asymmetries, misleading information, and conflicts of interest, how does the SEC plan to monitor and enforce compliance with these rules effectively? Furthermore, considering the concerns around the potentially chilling effect these rules might have on the SPAC market, what measures is the SEC considering to balance investor protection with maintaining a viable market for SPACs and their innovative approach to public capital raising? SPAC rules are all about preventing regulatory arbitrage, which can be harmful to our market. So the principle is simple: treat like things alike. Because of conflicts of interest and the complexity of transactions, SPACs raise unique investor protection concerns. Before we adopted the rules, there was an uneven playing field. But the end result is the same in both, whether it's a traditional IPO or it's a SPAC. That is, you're investing in a public company no matter what. So I believe investors should have the same transparency and the same legal protections, and that's what the new SPAC rules do. Now, at the same time, through its disclosure review program, the Division of Corporation Finance here at the SEC will review registration statements of the SPAC, IPO, or during the SPAC, IPO, and the M&A stage to monitor compliance with disclosure requirements, and if necessary, to give comments to registrants where they may be deficiencies. At the same time, the Commission can open investigations and bring enforcement actions if it believes that the rules have been violated. Now, as it's become clear to me during my tenure here as Commissioner, we have limited resources. We can't be everywhere all at once, so private enforcement is important as well. Investors can sue. If, for example, SPACs make unreasonable statements about a target's future revenues or other forward-looking projections. They can also sue the target company if it makes material misstatements about its business. So I hope that answers that question. The next question is from Imani Stokely, who asks, how do you think your extensive career in public service has contributed to your work as an SEC Commissioner and your ability to establish and enforce SEC laws and regulations? I am proud of my public service career, and through that time, I've gained a deep understanding of the value of effective oversight of our capital markets. And this mission is so important to investor protection and for the public interest. So in my role as Commissioner, I believe strongly that I carry an enormous responsibility to safeguard the public trust and to place the public interest, that of working families, above all others. Working families depend on public servants like myself to protect them. And I believe everything we do here at the SEC carries the power to protect working families from harm. When families choose to invest in our markets, they do so because they seek to build a better future for themselves and their families, and we must be there for them when they do. I believe strongly in that power and remain laser focused on protecting the interests of the investing public. And that comes from a belief that's been shaped by my own life experiences. I grew up in an immigrant working class family. As a Hill staffer, I was deeply immersed in the legislative response to the 2008 financial crisis. And I'll never forget the impact of that powerful life-changing experience. So combined, my personal and professional experiences have strengthened my conviction that elevating the interests of working families is our most important responsibility. I have and will continue to help shape our rules to be as protective as possible for working families. Investing is an optimistic way of channeling one's hopes for the future. It represents an opportunity for wealth building, but it also carries risks. And families are often investing in our markets to save for college, to buy a home, save for retirement, for many purposes. But in essence, it comes down to achieving the American dream. So in that process, I see it as our responsibility to protect working families and to work on their behalf as effectively as possible. The next question comes from Christian Joy Walker, who asks, by requiring unregistered high-frequency trading firms to register as securities dealers, how soon do you expect these reforms to provide for more protection for investors and benefit our $24 trillion treasury market? We recently adopted a rule that further defined the definition of dealer. And as some of you may know, the treasury market currently is split between registered firms that operate with transparency and adequate capitalization and operational integrity, and unregistered firms with a significant presence in the market that don't operate in the same way. So ultimately, registered firms provide the market with key data that make it easier to discern and assess market risks. And these firms also comply with applicable financial responsibility and risk management rules. And without these reforms, our capital markets and financial regulators would continue to lack key data and therefore limited oversight over an unregistered segment of the market. This particular rule is of relevance, significant relevance to the Treasury market. And Secretary Yellen, in a speech last year or two ago, referred to the Treasury market as the bedrock of our financial system. So this particular adoption is essential for the resiliency of that market, which plays such a vital role in public finance and in world finance generally. So it also addresses some of the shocks that we saw during the pandemic, the dash for cash, and which also highlighted the need for additional transparency and resiliency and measures to protect that market. So this adoption, to the question regarding the timing, we'll see these benefits in early 2025 when the rule comes into being. So thank you for that question. Moving on to the next question from Darwin Perry. Please elaborate on how your how your previous involvement in the public interest sector, particularly your time as an aide to Nancy Pelosi, Speaker Nancy Pelosi, helped shape your viewpoint regarding the SEC's oversight of the financial markets. Also, what specific insights do you draw from your experience in the public sector as an SEC commissioner responsible for regulating the U.S. securities markets? For someone like myself with a strong passion for public policy and a commitment to public service, it was a great honor and a very rewarding experience. Speaker Pelosi's exceptional leadership skills brought transformational change to our country. She is an extraordinary leader, a historic figure, and she accomplished extraordinary things during extraordinary times. Her record of achievement as House Speaker is unprecedented in American history, and witnessing these historic achievements up close was the opportunity of a lifetime, and I'm very proud to have been part of that. That experience, combined with my own personal experience, really informed how I approach this role now. And more than anything, my own personal conviction about the importance to our country of fulfilling the SEC's mission in the most effective way possible. It is essential for our capital markets, for our economy, and for our country's future to ensure that our capital markets remain fair and transparent, that there's a level playing field so that all who wish to access our markets can do so safely and with confidence. Markets change constantly, and we have an obligation to keep up with that change to protect the public. And it's important to ask questions about how to strengthen and fulfill our mission. And I have numerous questions I keep in the back of my mind every day as I think through all of the issues that come before me, all the matters that come before me, such as are rules keeping up with the changing landscape? How can we foster meaningful retail investor participation in our markets? And what additional information do they need to make informed decisions? How can we facilitate access to capital for smaller businesses and entrepreneurs from underrepresented communities? How is technology changing the consumption and transmission of investment advice? How can we ensure that the Commission is fulfilling its mission in as broad-based a manner as possible? Where can we do a better job with the tools we have to expand our reach to everyone, not just those who are supported by the current system? So these are a sample of the questions that are important to me, that drive my thinking as I, again, work to fulfill our mission as effectively as possible. That concludes my answers to the questions and my remarks, and I appreciate the invitation to be here today. And again, thank you for all the important work that you do, for gathering here today to share ideas on how you can continue to offer your talents in this space to ensure that investors are protected. Thanks very much.
Hello, everyone. I'm Rich Best, the director of the SEC's Division of Examination. I'm glad that I had this opportunity to thank you for the important work you're doing protecting investors. As is customary, I'll begin by noting that the remarks that are given today are in my official capacity as the director of the SEC's Division of Examinations, but do not necessarily reflect the views of the commissioners, or other members of the staff. Exams is an 1,100-person team spread across the SEC's 11 regional offices, plus the home office in Washington, D.C. We conduct risk-focused examinations of the SEC's registrants, such as investment advisors, broker-dealers, and clearing agencies. Guided by the Exams Division's four-pillar mission to promote compliance, prevent fraud, monitor risk, and inform policy, our experienced and talented staff gain a unique perspective of the industry and risks in the markets. This insight impacts both what we do as a division and the commission more broadly. Our work helps inform rulemaking initiatives, improve industry practices, and identify misconduct. The Exams Division is committed to doing its part to protect investors and safeguard against financial fraud. Like the students here today, my team is deeply concerned about investors who have been defrauded or harmed by their financial professionals. Financial markets, which are complex, are growing even more complicated, and even the most seasoned investors can be victims of fraud. Through our examinations, we promote compliance with the federal securities laws and try to prevent fraud before it happens. In some instances, though, examiners do find indications of possible fraudulent practices, and we refer those matters to the SEC's Enforcement Division. Financial fraud can be especially devastating to individuals and families who do not have the means to use the legal system to try to recoup their losses. This is where investor advocacy clinics provide an invaluable service. That is, free legal representation to investors who could not otherwise afford a lawyer. The clinics often serve as the best and sometimes the only instance for investors to recover damages in disputes with their financial professionals. I would like to personally thank you and your professors for your dedication and commitment to assisting investors in need. I hope your example will inspire other law schools to turn their attention to the growing need for this public service. Investing in our capital markets is not risk-free, but financial professionals should never be the source of risk. Thank you again for the great work that you're doing, and now I will turn the program over to the Pace University and Seton Hall University Schools of Law. Thank you.
Thank you, Director Best, and good afternoon to everybody. I know that we're chugging along here. My name is Robert Marchman, and I am Senior Policy Advisor on Diversity and Inclusion in the SEC's Office of Minority and Women Inclusion. This panel is going to discuss how DEI impacts the work of law school clinics. I've participated in today's excellent summit. There's been a lot, frankly, of discussion that has raised the issues that we're going to talk about, but we on this panel today are going to specifically hone in on DEIA. And just so there's a clear understanding as to why it matters, the SEC recently issued its own DEIA strategic plan. And in the plan, we noted that at the SEC, we recognize that diversity, equity, and inclusion and accessibility are the cornerstone to the U.S. Securities and Exchange Commission's three-part mission. So at the SEC, we feel that this process is something that is core to our important three-part mission. I have been pleased and fortunate over the time leading up to this summit to have been had the opportunity to meet students from Seton Hall Law School and Pace University, my colleague and I, John Sanders and I. I've been really impressed with the conversations we've had. So before we begin, I would like each of them to just introduce themselves briefly, then we'll jump into the question. Jaylene, please start.
Hi, my name is Jaylene Mejia. I'm currently a 4L at the Pace University School of Law, and I am a clinic participant at the Pace Investors' Rights Clinic.
Hello, everyone. My name is Steve Pisano. I am also a 4L student at Seton Hall University School of Law, working under the tutelage and supervision of Professor David White.
Hi, I'm Abby Mashasha. I'm a 3L at Pace University School of Law, and I am a participant in the Fairbridge Investor Rights Clinic along with Jaylene under the supervision of Janine Marashulo, who is sitting right there.
Good afternoon, everybody. My name is Julia Wood, and I'm a 3L at the Seton Hall University School of Law, participating both in the Seton Hall University School of Law Settlement Advocacy Conference Program and the Investor Advocacy Program.
Thank you all. So I want to start the first question with Jaylene, which is, why is diversity, equity, and inclusion important to you as a law student and future lawyer?
Thank you for your question, Robert, and thanks to the SEC for providing this opportunity for all of us to speak today. I think DEI, on a personal note, is very important to me as a first-generation American, first-generation law student, and a non-traditional student working and going to law school and studying to pursue what I want. I believe DEI is incredibly important, especially in informing how I wanted to, show up and interest myself in a career of lifelong public service. In a more objective sense, I think as a future lawyer, it is incredibly important to promote DEI within the legal field. Certain studies conducted by the American Bar Association in 2022 showed that out of the 1.3 million lawyers in the United States, less than 2% are Hispanic women. And as such, that creates a gap in understanding, learning, compassion, empathy for some of our neediest clients. When we think of the investor pool, sometimes our first thought might be that wealthier investor. However, from personal experience in the clinic, a lot of our clients are first generation or immigrant Americans, or immigrants, excuse me. They oftentimes have English as a second language, and they have little to none financial literacy. So as such, I think DEI places an important emphasis on bridging the gaps from the systemic inequities within our legal profession.
Jaylene, thank you. And I just want to underscore the point you made with regard to investors. It's important that we all understand and consider when we talk about the protection of investors, it's not just certain groups of investors or certain classes, it's all investors that are the focus of the mandate of the SEC with regard to investor protection and the other core components of our mission. So I thank you. Steve, question for you. What new perspectives regarding investor protection and inclusion have you gained as a result of your law school clinic experience?
Yeah, thank you for the question, Robert. During my time with the Seton Hall University School of Law FINRA Investor Advocacy Program, I've been fortunate to work closely with people struggling to find their way through the complexities of financial markets. As our state's, New Jersey's, only investor advocacy program, our program reaches a wide range of audiences, from high school students to senior citizens, all across the state. New Jersey stands as a testament to the strength found in diversity. Its people, hailing from a myriad of backgrounds, contribute to a rich tapestry, making it a unique microcosm of global culture. Additionally, its industries, including manufacturing, technology, agriculture, and its role as a home to financial and pharmaceutical giants, reflect a dynamic economy that is constantly evolving. Like Commissioner Peirce said earlier, and many of our colleague advocates in this room have said, education is at the root of our mission. We want to make sure that investors' rights are protected through legal advocacy, and also that our next generation of investors are educated and informed. One of the deepest things that I've come to realize is the complex network of obstacles that investors, particularly those from marginalized communities, encounter. This might be because of a lack of education about investing. It could also be because of an inability or an unwillingness to invest discretionary income into the market. It's become apparent to me that protecting vulnerable investors involves more than just legal solutions. It's also about providing education, ensuring access, and understanding existing barriers for minorities and low-income investors, and the need for making advancements that make investing more reachable and equitable. I've come to understand the vital importance of proactive education and access to information. By equipping people with the knowledge and tools they need to make informed choices and requiring greater transparency and disclosure, we can greatly diminish the risk of people falling victim to fraud and exploitation. My experience has shown me that through our efforts representing clients in our sister clinics in the District of New Jersey and Southern District of New York, and educating underserved investors, I see now firsthand the power that future legal professionals can have on driving improvements in the marketplace. One important insight I've acquired is the importance of empathy and inclusion in protecting investors. Understanding and meeting the varied needs and challenges of investors from all backgrounds is essential for creating a fairer financial system. In an industry where women and minorities are still underrepresented, drawing in professionals and fostering opportunities for a diverse workforce can encourage investment professionals to connect with individuals who may not reflect their usual clientele. Finally, the insights I've gained during my time in our program have deeply influenced my perspective on investor protection and inclusion. As I continue conducting educational sessions throughout my state, and eventually as a practicing lawyer, I am dedicated to using these viewpoints to champion a fair and orderly market that is accessible, just, and equitable for everyone.
Thank you, Steve. I want to pick up on one point that you made with regard to regulation. So we're here at the SEC. One of the things that we do is listen to the public. We don't have all the answers. So Abby, I'd like to ask you the following. What steps can regulatory agencies take to promote the importance of DEIA in protecting investors?
Yes, so I think one of the most important steps that regulatory agencies can take is to continue to promulgate rules and regulations that attempt to keep up with the rate that AI and behavior tracking technology are developing at, and all technological climate. Recently, last semester, we had the opportunity in our clinic to write a comment letter on NASA's proposed change to their model conduct rule on dishonest or unethical business practices. And it focused heavily on the sophisticated digital engagement practices used by robo-advisors and other types of AI. But we think that there's still more opportunity for people to be protected from these behavior learning technologies that send things like push notifications to customers, especially a younger demographic, that will treat these as a prompt to create a trade and invest their money without having a full understanding of the risks that are inherently associated with these investments. So we think that holding brokers and these apps liable for these sort of engagement practices is really important, and the way to do that is by enacting rules and regulations and keeping up with ever-changing technology. And this doesn't just impact the younger generation. As mentioned prior by one of the other schools, AI is a significant risk to the elderly population with scams and voice recognition technology that can recreate the voice of a family member. I believe that the SEC and other regulatory agencies can also have a more front-facing presence online and even on social media to educate less financially literate investors on their rights as investors and their methods of recovery available. If you don't know what you don't know, and less financially literate investors may take to heart information that they see online on social media through other ways that are not through broker-dealers and use these to decide what investments to pursue. Youthful investors should be fully informed of the inherent risks associated with investing, especially with the rise of app-accessible trading in their hands. This also impacts the English as a second language class, where they're more likely to be taken advantage of by an unethical broker that can contact them through social media, through all these platforms, without having proper information. And continuing to have these clinics that represent these populations that aren't otherwise able to access representation is super important.
Thank you, Abby, so much. So we're really fortunate today, learned so much from the earlier panels, and we still have a couple of panels to go. And as a number of speakers have noted the importance of the law school clinics, I was fortunate when I was in law school to actually participate in a clinic, and it's benefited me in my career. So, Julie, I have a question for you, for those who may be watching. Do you consider the offering of a legal clinic to be a competitive advantage for a law school? And if so, why?
Absolutely. Offering a legal clinic can be a significant competitive advantage for both the law school and the participating students. As you've heard all day, there are numerous reasons as to why that might be. And I would go even so far to say that not offering a legal clinic deprives students of these enriching opportunities and also puts law schools at a competitive disadvantage. Clinical programs are enriching to students' educational experiences for several reasons that I'll go through. Obviously, the hands-on experience. Clinical programs foster practical skills that are developed through the actual practice of law. I'll bring back our golf clinic analogy earlier that, you don't really learn about thinking about it or, hearing about it, but actually doing. And that's the opportunity that's really unique that you're provided through a clinical program. We learn through drafting legal documents after comprehensive research, correspondence with different FINRA personnel or even opposing counsel. You argue in front of arbitrators, judges, mediators, and all of this lends to both your professional skills and your personal skills. These have elevated me personally, and I know that it will do the same for my counterparts that are in the program now, as well as those who have the privilege to participate in a clinical program in the future. Also, we can look at client interactions, and with this, we see when advocates are doing client interviews or are in regular communication with clients, it allows for students to gain insight on the practical aspects of client counseling, as well as the ethical considerations associated with those client interactions. At the Seton Hall Investor Advocacy Program, I've really been able to refine a skill we call compassionate agents of reality. And with that, it's really telling clients not what they want to hear, but what they need to hear. And that's a skill that I otherwise would not have been able to refine and to utilize in a classroom. In addition, there are many networking opportunities. The collaborative nature of a clinical program allows for students to improve their interpersonal skills with their peers, as well as their professional skills in communicating with others working within the field. We can also look to community engagement opportunities. Pro bono services increase access to justice in underserved communities. This boosts the reputation of the law school and fosters a sense of social responsibility in each school's community. Also, we look to how clinical programs differentiate a law school from others. Law school is competitive, whether it's in applying as a student or once you're in the classroom, but it is also for each of the schools individually. By offering a clinical program, a law school is able to set itself apart, and this largely lends to postgraduate employability. employers really like to see when a student is able to get that hands-on experience during school. Sure, we get our clerkships or our internships, summer associateships, whatever that may be, but when you're actually regularly practicing throughout the semester, you build a sense of confidence in yourself and just a general knowledge base that employers really like to see. Lastly, we can look to alumni networks and how students who are alumni are likely to contribute back to the school if they've had a positive experience with the clinical program and are able to look back and be reminded of how that clinical program was able to advance their career. Personally, I know that I've learned so much out of the investor advocacy program, whether, like I said, that's personal skills and communicating with the clients, communicating with opposing counsel, or even communicating and collaborating with my peers. It's not always just the legal research or the drafting or the arguing, but really altogether it's been by far the most enriching experience and valuable experience that I've been able to have during my law school career. And I hope that other schools are able to provide that to students so they might have the same opportunity. Thanks.
So let me, Jaylene, we have a couple of minutes left, so I just want to give you the opportunity to, Julie, thank you. That was really, I think you all can see why we were so impressed with these students, and the future is bright. But just in a couple of minutes, I'd like you to talk about competitive advantage that you see from participating in the clinic.
Definitely. I believe that participating in a clinic gives you the front-facing opportunity to deal with clients, to handle communication and collaboration with other students, and also make them, necessary and ask those necessary questions, perhaps maybe even make those necessary mistakes that you might not want to make, post-grad in your employment. You have the opportunity where you can go to your supervising attorney, such as I have multiple times, to say, I don't really get this, I don't understand this, can you help me? I believe that that gives such a competitive advantage because it helps individuals be able to understand and identify things that they need to work on, things that they can improve, and skills that they might have not even realized that they already have. As Julie mentioned, it also gives a competitive advantage in terms of employability. I mean, being able to do this work physically does provide an invaluable experience to each and every student that participates in a clinic in their law school experience.
So I think we've reached our time, and I want to thank each of you for taking the time today to participate in today's summit, but also for the work that you do in assisting with the important mission of protecting the investing public, which is critically important. As you heard Commissioner Lizarga, Commissioner Peirce, and others say, it's really important that we do that to ensure the integrity of the market. So if you can please join me in a round of applause for the panel. Appreciate it.
I'm delighted to introduce remarks by Mr. Eric Girding, the Director of the Division of Corporation Finance. Mr. Girding joined the SEC in October 2021 and led the legal and regulatory policy in the Division of Corporation Finance before becoming the Director of the Division of Corporation Finance in February 2023. He holds an undergraduate degree from Duke University and a JD from Harvard Law School. Mr. Girding is also a distinguished scholar and educator in securities law, corporate law, and financial regulation. He taught at the University of Colorado School of Law School, the University of New Mexico School of Law, and as a visiting professor at the University of Georgia. He has published numerous articles on topics such as financial crises, systematic risk, and corporate governance. He is also the author of the book Law, Bubbles, and Financial Regulation. Prior to his academic career, Mr. Girding practiced in New York and Washington, D.C. offices of a large international firm. Please give me a warm welcome to Mr. Eric Girding.
Well, thank you all for having me today. First, I have to give the standard disclaimer. I am speaking today in my official capacity as the Commission's Director of the Division of Corporation Finance. My remarks do not necessarily reflect the views of the Commission, any commissioners, or any other staff. Let me just sort of start out by saying I was given a task today, and I'm very goal-oriented. So my goal and my task today is to get 2 new investor advocacy clinics around the country. So what's it going to do to take one of you and put it in an investor advocacy clinic? And one of those 2 is going to be west of the Mississippi. So those are my goals. Raise your hand if you're from west of the Mississippi. All right, and now I know who's going to get the hard sell later on. Let me say I'm a true believer in investor advocacy clinics and in clinical education in general. And for me, it's personal. And let me tell you why it's personal with a little bit of my story. So I grew up in New Jersey. And both of my parents were public servants. Both of them worked in the New Jersey state government. And it was not glamorous all the time. It certainly was not well paying. They did not make private sector salaries. But growing up, I looked up to them immensely. They had a tremendous amount of idealism for working in the public sector, for being public servants. And unlike me, they were fairly quiet. They never sought the public spotlight. They didn't get their names in the newspapers, with one exception. They just quietly did their job on behalf of the people of the state, day in and day out. And that idealism, that public service, I think motivated my interest in an early age in government and public policy. And I majored in public policy in college, and it took me a long time, but here I am finally doing and working in public policy. And after majoring in public policy in college, I went to law school and I gravitated towards business law. And why did I gravitate towards business law? Because I really didn't understand it and I thought it would be a challenge. I didn't really know anything about business. I didn't know anything about business law. And hopefully you've forgotten which law school I went to by now, because to be honest, I didn't learn much in the business law program in law school. It just didn't click with me. And don't think I'm insulting my law school, because I don't think my professors thought I learned very much either. So here's dirty secret number 1 about me. Guess which class I got my lowest grade in law school? You're gonna, I have one of my divisional leaders here. Duck, you're gonna have earmuffs on this. Not corporations, securities regulation. I mean, come on, now we're here at the Securities and Exchange Commission. Got some revenge on that securities law professor, right? Because now he's still there and he's got to teach the rules that we're working on. You know where I did learn something in law school? I did learn something in the clinic. And at that time, that law school did not really have a business law clinic. But I worked in the immigration and refugee clinic in law school. And that was a tremendous experience, not just in terms of doing public interest work, but actually learning by doing. And I think you've heard from a number of speakers in the last panel and throughout the day about how much you learn and how much the clinical experience can teach you that the classroom and podium experience cannot. as per my introduction, after law school, I did go to work in a big law firm, and I worked there for a long time, although I continued to do pro bono immigration work at the firm. And I also always wanted to teach. I wanted to teach law school. So here's dirty secret number 2 about me. It took me 3 times on the job market before I got a job as a law professor. And then here's the other revenge I get on law professors, right? All those people who refused to hire me the first 2 times, now, like, I can get my revenge at them on conferences too, right? Like, hey, remember me? Did okay. This is the thing, when you're from New Jersey, you have a chip on your shoulder all the time, right? This is part of New Jersey citizenship. I went on the market 3 times, and finally the University of New Mexico took a chance on me. Why did they take a chance on me? Because one of my law school professors really knew me well and took a very active interest in me. Do you want to guess which law school professor that was? It was not the securities law person, right, where I got the lowest grade. It was not him, Howell. It was the clinical law professor, right, who was in the immigration and refugee clinic director. And I had gotten to know her really well. She had gotten to know me, and I think she believed in me. And she was the one who made the call to the faculty, and that's how I got my break, right? So the clinical legal experience has paid dividends for me, like, all across the board. And when I was at the University of New Mexico, the University of New Mexico has a fantastic clinical program. I think it was the first or one of the first law schools to actually require clinic as a graduation requirement. And I actually taught, not every semester, but I taught a little bit in New Mexico's transactional law clinic. And that was a tremendously gratifying experience. I later moved to the University of Colorado, and when I was at the University of Colorado, I finally got involved more, less in just a purely academic pursuits, but also very heavily in policy work and working with different groups here in DC. And now I'm here in DC. I finally, after, I'm now in my late 20s. After a couple years since entering college, I'm finally doing what I was always interested in, which was actually working on public policy. And I work with 470 staff in the Division of Corporation Finance. We have a couple of them here in the audience. These are some of the most talented accountants and lawyers practicing in the securities space that you will ever see. This is a tremendous group of people. I may be a professor, but I learn from them on a daily basis. And it is just an honor and it is a joy to watch them practice their craft, and not just practice their craft for any old client, but for the client of the American people. And it's just amazing, like, to see that on a daily basis. And I think what you'll see by this story is a couple of things. One lesson, obviously, I have a chip on my shoulder. I'm from New Jersey. But I think you'll see that clinical experience played a huge role in my career development and in my life. And I think when you see these things, there's some common themes. One, I'm the type of person who learns more by doing. And I think that is one of the real benefits of clinical experience. I also think that you learn skills in a clinic that are portable to business law careers and to government service. It's intellectually challenging. It is gratifying because you are doing something that is for a greater public purpose. Now, my career has taken a very nonlinear path, and I'm grateful for all the opportunities I've had. But how much more direct would my path have been had my law school had an investor advocacy clinic? And I think, like, my belief is it would have been a lot more direct. So let me now start the more direct pitch. Like, raise your hand again if you're from west of the Mississippi. There you are. You like have a little bit of hesitancy, like, I'm not sure I want to raise my hand, right? I'm going to call on you later on because I'm still a Socratic professor. Here's my pitch. Number one, it's about social justice. So I think you've already heard this throughout the day. And I know that clinical faculties care a lot about social justice. The University of New Mexico faculty sure did. And retail investors deserve representation too. So by giving representation to retail investors in disputes, you are serving, you are meshing with the Commission's overall mission of investor protection. Now, it's been drilled into me that I can't just mention our investor protection mission, so don't worry. Like, I love investor protection, Christina. But we have a multi-part statutory mission. So I'll just state for the record that it's also important for capital formation. Investors who feel the system has integrity will have more confidence in our markets and will invest more. So number one, investor clinics are about social justice. Footnote, they're also about capital formation. Number two, investor advocacy clinics connect students interested in business law to the clinical experience, which is something that was sorely missing when I was a law student. I think more and more law schools are developing clinics that can appeal to and serve students interested in business law, but this is a great way of doing that. Number three, an investor advocacy clinic is also potentially about training litigators. So we know very well the dirty little secret that we do not teach 1Ls in law schools, which is that a huge portion of our disputes today are settled and resolved in arbitration, not in state or federal court. And the types of skills that you need in arbitration, where better to get them than in a clinic that focuses on arbitration and dispute resolution. It's also the other sort of dirty little secret that many of my current colleagues around in law schools don't necessarily want to say out loud, is that a huge portion of litigation and a huge portion of what our graduates do who litigate when they graduate is about commercial litigation. It is not about constitutional litigation. It is not about the litigation areas that many of my colleagues practiced in themselves. So by connecting students to experiences in commercial litigation and in securities disputes, I think we are doing a better job of training students interested in litigation. My final reason is that investor advocacy clinics build a pipeline for public interest and they build a pipeline for public service. Now, there are a lot of unhappy associates in law firms around the country. And a lot of those unhappy associates, right, I think are interested in doing something that is more public-minded, whether it's a public service career, whether it's a public interest career. And they don't necessarily know what kinds of opportunities are out there, or their mindset is not really oriented in that direction. But by giving them a clinical experience you can have the same impact that my clinical professors had on me, which is to let me know early on that there were opportunities and there was a greater, there were other purposes to which my skills could be put to use. And I hope that for those of you who are students, for those of you who are teaching students, that you understand that an investor advocacy clinic can help give them the same kind of joy and same kind of purpose that I feel working here at the Commission every day, and that I think a lot of my colleagues feel as well. It's certainly evident that they feel that way because they bring a certain energy every time they walk in the door, every time they are representing the American people. And working for that public purpose is just immensely gratifying in a way that I have never experienced before coming to the Commission. And let me close with what I've told the division at least once, maybe several times, because I'm getting to that age where I repeat myself. What I think, what I've told the division is when you go home, when the accountants and staff that work with me in the Division of Corporation Finance go home, I am pretty sure that some loved one looks up to them in the same way that I looked up to my parents all those years ago. And what I would want is that many of you students, many of the students of the clinic directors who are here get to feel that experience too. Thank you very much. And I think next on the program, I will introduce our next speaker. Are we ready for the next speaker? Okay, so I am pleased to introduce Gurbir Grewal, who will be making some pre-recorded remarks. He is my good friend. He is the current director of the Division of Enforcement since July 2021. Like me, he is from New Jersey. Like me, he has a giant chip on his shoulder. The nice thing of him giving pre-recorded remarks is I can say whatever the heck I want about him, and he's not going to really know it and can't defend himself. So Gurbir came to the Commission from his previous job as State Attorney General of New Jersey. He also served as chief of the Economic Crimes Unit in the U.S. Attorney's Office in New Jersey and was both a state and federal prosecutor. Gurbir received a BS-FS degree from Georgetown University School of Foreign Service and a JD from William & Mary. So wherever Gurbir is about to appear, Gurbir, I summon you.
Good afternoon, everyone. It's a pleasure to speak to you all during the Investor Advocacy Clinic Summit. I'm Gurbir Grewal, Director of the SEC's Division of Enforcement. The Enforcement Division is responsible for investigating potential securities law violations and prosecuting the Commission's lawsuits against alleged violators. I know you have a packed schedule. You've already heard from many of my colleagues today, and you'll hear from a few more after me. And you're going to be hearing from our other clinic students. So I'll keep this short. I want to thank you. The work that you're doing, providing free legal services to underrepresented investors, is so critically important. As you all know, investors, especially the ones you're helping, can face many challenges navigating investments. There can be language or cultural barriers, or issues with financial literacy. And that's just to name a few. At the same time, we know that there are bad actors out there. Bad actors that prey on those vulnerabilities. Bad actors that promise easy, risk-free money. We see the results of that every day in the Enforcement Division. Investors who are the victims of Ponzi schemes. Investors who are the victims of affinity frauds or other scams. Or investments that just aren't right for them. And I'm not talking about millionaires who can take the hit. I'm talking about regular people who lose their life savings, their retirement accounts, their kids' college savings accounts, It's absolutely heartbreaking and gut-wrenching. So I'm particularly grateful to you for the work you're doing. By helping investors make better informed investment decisions, you can help prevent additional victims. With your diverse experiences and communities, you all have tremendous reach and you have incredible credibility with the folks you're speaking to. You can reach people where we can't. You can literally save a family's financial security. That's really impressive for a law school clinic. And it's pretty cool for a career too. If you're interested in a career in public service while holding bad actors accountable and standing up for others, I encourage you to explore a career at the SEC. We have many great colleagues join us through programs for current law students and recent law grads. I'm now really pleased to welcome law students from Cardozo Law School, Howard University School of Law, and the University of Pittsburgh School of Law, who will present the Clinic Experience Part 2. Thank you again for spending a few minutes with me, and thank you again for the incredible work that you all are doing. I hope you have a great afternoon.
Hello, my name is Lisa Skrzecki, and I'm joined by my colleague Richard Dominguez, and we're here for the panel number 4, the Clinic Experience. I'd like to welcome first our representatives from Cardozo Law School, Samantha Sanchez and Jamie Sung. From the University of Pittsburgh, I do have to say, hail to Pitt as an undergraduate graduate, Dylan Kim and Daniel McTernan. And from Howard, pleased to welcome Imani Stokely and Ashley Washaya. Thank you so much for joining us.
Thank you so much for the introduction. Good afternoon. My name is Samantha Sanchez, and this is my colleague, Jamie Sung, and we're here representing the Cardozo Securities Arbitration Clinic. Next slide. So we receive intake calls really from all over the country, and as previous panelists have mentioned, there's more need than there are actually clinics. So even though we're not able to take on cases outside of New York, we always make sure to be able to help them in whatever way we can, such as referring them to different resources that are in their home states. Next slide. So at our clinic, our motto, our main focus is really that we're focusing on the whole client and their needs. So that means more than just winning the cases, which of course feels great, but there's more to it for us. At our clinic, we speak a combined 12 languages, which really helps us reach the really diverse New York community that we're serving. And a great example of how we are really trying to make an impact in our whole clients' lives is a story of an 85-year-old woman who we were representing, whose retirement account was both improperly managed and distributed out of its tax-protected status. So this meant that all of her money was being treated as income, and this then led to her housing and her medical benefits being at risk. So in order to restore her benefits, we had to file proceedings with the Social Security Office, Department of Finance in New York, and the IRS. And another example on a case that Jamie and I are working on now, our client has a terminal illness, and one of the, it was a great learning moment at our clinic was drafting his will, which is, it's really important for our clients as well. Next slide. And connected to the idea that we speak so many languages, and a lot of us are really familiar with all the communities that we're serving, is that we are able to build more trust in our relationships with our clients, and that ultimately means that we're able to build the best case possible because we really have all the information we need to be able to advocate for our clients. Next slide.
Thank you, Sam. So in connection with our whole client approach, we also offer a variety of legal services, including
naturally representing our clients in FINRA cases, as well as adversary proceedings on investment fraud claims in bankruptcy court. And we also bring federal securities fraud cases in federal court. We help clients through every stage, from the initial intake, of course, all the way through to settlement negotiations. Next slide. And a recent study showed that the top 5 districts for securities and investment fraud offenders were in the Southern District of New York, Eastern District of New York, Central District of California, the Southern District of Florida, and the District of New Jersey. As you can see, the top 2 are in New York, and we're pleased to say that we offer services to the entire New York State. And one example of this is a case we wrapped up earlier this year, or earlier last year, I should say, where in the Southern District, where we were able to recover the full amount for our client. But we did find that several other investors came forward that had also fallen prey to this fraud. And unfortunately, due to the limited resources of our clinic, we couldn't service or help all of these individuals. And yeah, that just demonstrates the incredible need for legal services of this type. Next slide. And something that we found is that fraudsters really do target the most vulnerable. Silence surrounding financial education can become a tool for people to take advantage of others. And we found that people nearing retirement age with shorter investment return horizons, particularly those from ages 60 to 69, can be vulnerable targets for fraudsters. Next slide. And I think initially, maybe when I was thinking of investment and investment fraud, I was thinking, Wolf of Wall Street or something like that, but it's actually not what most people assume. And we found that a lot of investors are actually people who are investing their retirement accounts or what savings they can scrape by. And a lot of the time, it's not disposable income to them, but very real their financial livelihood that they're choosing to invest for the sake of their future. Next slide. And that's why, as our director likes to say, our goal is really to put ourselves out of business. We are required to do community presentations for vulnerable communities throughout New York. And as you can see on the screen, some of the communities that we're working with this year include from young people in high schools to elders, as well as immigrant populations in Queens. Next slide. And yeah, this is our clinic. We're so proud of our incredible team, and yeah, we'll be happy to take any questions.
Hi there, Richard Dominguez. In your presentation, you mentioned targeting the most vulnerable, and you mentioned vulnerable communities. Could you tell us a little bit more about the Center for Successful Aging and how it educates an older population?
Yeah, thank you for that question. So elders are often targeted because a lot of times they are isolated. They don't have people who they can turn to get the financial advice that they need, especially with something as important as retirement and possibly increasing healthcare costs. So what the center provides a lot of activities for everyone to really build a community beyond just the way that you can maybe be a little bit more isolated at home without a center like that. And one of our colleagues is going to be presenting there soon and how to invest wisely. Yeah, thank you.
Thank you. And in your experience, how do you think these scammers are making the initial contact with people nearing retirement age? And why do you think these demographics are being targeted as they are?
Thank you for that question. In our experience, a lot of the elders or older people in older clients that we've seen have been targeted through a variety of means, sometimes through social media or other times just by choosing to invest with the wrong people. So it really comes from a variety of angles, which is why we try to reach out to as many communities as possible. Thank you.
Thank you so much. And next up is the University of Pittsburgh.
Thank you so much, Lisa. Good afternoon, everyone. My name is Daniel McTiernan. I'm joined here by my clinic colleague, Dylan Kim. Today we'll be discussing the University of Pittsburgh's, quote, Securities Arbitration Clinic, is what we call it at Pitt. We will be discussing the clinic experience as it relates to the University of Pittsburgh. Next slide, please. The clinic at Pitt has two primary goals. One is to increase the individual investor's access to fair process and economic justice, and the second is to foster an experiential learning ground for students who are interested in commercial fields of law as well as litigation. Next slide, please. Because we have a limited amount of time to talk today, we would like to limit our discussion to three key elements of the clinic experience at Pitt. First, I'm going to discuss our clinic's dedication to representing individual investors in disputes, namely those within the FINRA arbitration framework. Then Dylan will discuss our clinic's participation in FINRA's development of new rules and regulations, and then he will discuss our competitive in-class simulation. Next slide, please. So what can elite client service look like at the law school level? Maybe the best way to approach this question is by presenting a case study, a recent case that came to our Securities Arbitration Clinic. So in this case, this paradigmatic clinic client was an elderly person who had fallen for one of the myriad internet scams that have become all too prevalent. Our clinic alleged that our client's investment advisor knew about what was happening to our client, and the investment advisor failed to act according to their fiduciary duty. Now, because the monetary value of this case was not significant enough to draw the attention of practicing securities attorneys, this is why the client came to the clinic. Now, this advocacy does not always look exactly like the traditional lawyer-client relationship, but it does retain some of the same key goals and duties. So what is it about this advocacy at the clinic level that does lead to success over and over again? We believe that it is the nature of the clinic itself that leads to such success. The combination of students' eagerness to participate in real cases and also their willingness to divide work amongst each other, faculty's academic appointments and their expertise, all combined with the communal lack of concern for monetary gain and contingency fees, is something that really creates a perfect storm that leads to both client success and a robust legal education. After we achieved success in the case I told you about, we asked our client's power of attorney to write something about what they thought was the importance of investor advocacy clinics. Next slide, please. I won't bore you with this whole quote, but the key points here are the first and last sentence. The first sentence here: in my honest opinion, the service that your clinic has provided is becoming increasingly necessary in the face of elder financial victimization and scamming. I hope that others in our situation have access to this type of help in more universities nationally. This sort of elite client service is not something that's unique to Pitt. Investor advocacy clinics across the country, including the other clinics on this panel, provide a similarly elite and vital service. The more investor advocacy clinics that appear across the country, the more likely it is that individual investors will achieve economic justice, including and especially elderly investors like our client. I'm going to hand it over to Dylan now to discuss some of the other goals and academic approaches of our clinic.
Thank you. Next slide, please. As Daniel discussed, our work with our clients is the primary benefit that we confer to individual investors as well as society at large. However, this is far from the only work or activity that we engage in for this purpose. We also post comments to proposed rules and regulations by FINRA and the SEC. We do this for the purpose of ensuring that individual and retail investors' interests are adequately represented at this stage. As many of the previous panels have discussed, mostly large investors and large investment firms are the only people with the resources and the means to actually comment on these proposed rules and regulations, which leaves a gap in which individual investors' interests aren't adequately represented. One current situation involves the current proposed rules regarding quantum computing by FINRA. And something interesting about this is that in our clinic, being in law school, we all have various backgrounds, so we're able to hone in on our backgrounds when doing this. So I won't bore you by going into over extraneous details about quantum computing. However, quantum computing has the potential to be incredibly disruptive to the securities industry. And beyond that, it is an activity that is prohibitively expensive, which results in it being exclusively engaged in by large investment firms. For this, we've decided to use our skills and our hands-on experience with clients to address their issues and concerns so that we can comment and try to get FINRA to consider these issues. Next slide, please. However, our clinic is not only valuable to our clients and the society at large, it is also incredibly beneficial to us as students. As many people have already discussed, the practical skills that we learn in this is something that is not otherwise achieved through the law school experience. Rather than learning the why, we are learning the how. How to see a case from beginning to end, how to conduct due diligence, how to ask the right questions of our clients, and most importantly, how to counsel our clients throughout this entire process. The ability to act as certified legal interns and have real-world interactions with clients presents us with an experience that would otherwise take years to obtain. Because of this, we're able to start our careers in the legal profession with experience that we would not have achieved otherwise. As many people know, when you enter big law, it's mostly due diligence and doc review. You're not in the field actually working with clients and doing everything. So this gives us a step up against everyone else. There's no wonder why so many of our clinic alumni have gone on to careers at FINRA and the SEC. Next slide. Beyond our actual work with clients and responding to proposed rules and regulations by FINRA, we held an internal triathlon consisting of a negotiation, mediation, and arbitration round. For this, we used the 2020 problem from the Securities Dispute Resolution competition that used to be held at St. John's University. We used this problem because this problem included not only the basic facts, but this was the only problem in which we had both sets of private facts for the claimant and the respondent. Our clinic split into two separate teams and were able to get hands-on experience through a negotiation and a mediation with an experienced mediator. Beyond that, the most important part of this competition was the arbitration round. As people have already discussed and many people in this room are familiar with, most cases settle before the arbitration process begins. Therefore, going through a mock arbitration was incredibly beneficial to us as students. For this, we had clinic alumni who have roles with FINRA and the CFTC act as our arbitrators. We split in two different teams, as I mentioned before, and for each side, for the claimant and the respondent, we further split into different roles in which one party had the opportunity to act in the opening and direct examination role, while the other party was able to act in the closing and cross-examination role. This experience and the feedback that we received from experienced attorneys at both FINRA and the CFTC was incredibly beneficial to us and not something that could be replicated in any other law school environment. Next slide, please. As we have mentioned, our experience in the clinic has been one of the most beneficial aspects of our entire law school careers, and at this point, we would like to open the floor to any questions.
Thank you so much. We have just one question, but in two parts. If your securities clinic was not there in Pittsburgh, what would your clients do? And my second part is, how has your experience with this impacted your thoughts on pro bono once you start practicing as an attorney?
Thank you for that. That is an excellent question. As has been previously noted, these small claims aren't attractive to securities attorneys, and a reason for that is the fact that they're going to have to do the same amount of work regardless of what the ultimate settlement is, so people are more interested in pursuing large claims rather than small claims, which leaves these investors who are the most vulnerable without any other recourse. Without our clinic, they would have to represent themselves pro se most likely, or they would struggle to find an attorney and would be at a competitive disadvantage against the lawyers that these large investment firms can afford. And to speak on the second question about how it's changed my thoughts on pro bono work, it's given me a deeper respect for what is involved. Pro bono work involves the most vulnerable people in our country and in different communities, and as a result, it's something that is very necessary. Thank you.
Thank you so much. And finally, I'm pleased to introduce DC's own Howard University. Thank you so much.
Thank you. Good afternoon. My name is Imani Stokely, and I'm delighted to be here today with my fellow presenter, Ashley Washaya. We are student attorneys in the Investor Justice and Education Clinic at Howard University School of Law. We wish to thank the SEC for hosting the 2024 SEC Investor Advocacy Clinic Summit and for providing us with the opportunity to participate on this panel. We would first like to start off by demonstrating the importance of law school investor clinics by first briefly describing our experience helping an elderly retired investor settle a dispute with his broker and obtain a recovery of nearly all of his funds. Secondly, we will discuss our general experience working as IJEC student attorneys, including the difficulties we face dealing with investors and opposing counsel, and the gratitude we have received from past clients.
So the retiree alleged that he was persuaded to close an annuity at one broker-dealer and transfer his funds into an IRA account at a second broker-dealer. The second broker agreed to handle the transfer so that it would be considered a tax-deferred rollover and not a taxable distribution to the retiree. However, the second broker failed to effect a proper rollover, which resulted in the retiree suffering a tax liability of many thousands of dollars. In fact, the second broker never even opened an IRA account for the retiree, and instead just deposited the funds into a brokerage account. Needless to say, the retiree was not very happy when he discovered this. Initially, the retiree tried on his own, unsuccessfully, to get the second broker to refund the taxes that he had to pay. When that did not work, the retiree turned to his son-in-law, a lawyer who was not experienced in this area of law, who was also unsuccessful in recovering his funds. Then the retiree made the wise decision to seek the assistance of a law school investor clinic and was referred to us by FINRA. We immediately conducted an extensive investigation of the facts and worked closely with the retiree and his wife to obtain and review the many relevant documents we needed. Once we determined that we had sufficient evidence to show that the second broker was at fault, we sent a draft statement of claim to the broker, which described the broker's misconduct and the financial damages caused to the retiree. We then sought to open settlement discussions with the broker's counsel, a very experienced securities litigator. Initially, the broker refused to accept any responsibility or discuss settlement. The broker claimed that the retiree never requested that his funds be rolled into a tax-deferred IRA, but that the retiree wanted his money deposited into a regular taxable brokerage account. However, after we provided broker's counsel with proof, including emails, that the retiree in fact explicitly told the broker to roll his money into an IRA, and the broker confirmed that he would do so. Counsel relented and agreed to open settlement discussions. After about a week of settlement discussions, we finally reached an acceptable settlement, resulting in the retiree receiving a settlement check for nearly all of the thousands of dollars in taxes he paid. One very important thing we want to point out is that after the parties reach an oral agreement to settle, it is then vitally important to carefully review opposing counsel's proposed draft settlement agreement. After reviewing counsel's draft proposed settlement agreement, we proposed several revisions needed to protect the retiree's interests. In this regard, we were able to persuade counsel to agree to a very narrow and limited release of claims by the retiree instead of a very broad general release proposed by counsel. In addition, we were able to include a definite 30-day period for the broker to deliver the settlement check, instead of counsel's proposal, which essentially said the check would be delivered to the retiree whenever the broker decided to do so. Since the retiree sought to possibly avoid any additional tax liabilities related to the settlement payment, we persuaded opposing counsel to describe in the agreement that the settlement payment is a reimbursement to the retiree. We were delighted when the retiree received his settlement check, and he expressed his sincere gratitude for our work on his behalf. In addition, this matter provided us the opportunity to accomplish our clinic's dual mission of assisting underserved investors while at the same time learning valuable legal skills, including negotiating with opposing counsel.
Generally, working in the IJEC has been an extremely rewarding experience. It is exciting to help investors recover losses when they thought there was no hope in recovering their money. It is also rewarding to help investors who feel they may have been abused and pushed around by large financial institutions and who are unable to battle against their enormous financial and legal resources. Being an IJEC student attorney also comes with its challenges. Sometimes the documents and information we seek from investors is hard to obtain. We must be mindful that we are asking investors to provide to us, complete strangers, very personal financial information such as income tax returns, brokerage account statements, their assets and liabilities, as well as information about their family relationships. In some instances, investors are reluctant to do so. However, after we demonstrate that they can trust that we will work in their best interests and that we need the information only so that we can help them recover their money, the investors usually provide us with the information we need. Additionally, dealing with opposing counsel can sometimes be extremely difficult. A lot of times, legal counsel for these large brokers are very experienced and try to take advantage of the lack of experience of clinical law student attorneys. However, that is when it is important that we seek the guidance of our experienced supervising attorneys to advise us on best practices in dealing with opposing counsel and how to get things done efficiently. Also, opposing counsel typically has many cases that they are working on. Therefore, we are the ones pressing to move the case forward expeditiously, which requires that we send many follow-up emails to obtain the information we need and schedule conferences with opposing counsel. All of these clinical law experiences provide us with a great opportunity to actually see what life as a practicing lawyer is really like and prepares us to deal with these challenges in our legal careers after law school. We would like to close by saying how wonderful it is when investors express their gratitude for helping them when they thought no one else could or would, and for actually working on their behalf to seek to recover their hard-earned and much-needed retirement funds. In this regard, we would like to share a recent client testimonial she sent to us after we filed her arbitration case with FINRA against one of the largest financial services companies in the nation after a lengthy investigation in which the broker refused to settle. In her email, the client stated as follows: "I do not know what to do with myself. You are absolutely amazing. This is so wonderful. Great God. Thanks is not adequate for all that you have done. Just reaching this point is amazing. Just amazing. I'm floating right now. Thanks to your wonderful professor for his excellent guidance. Thanks a million times, and even that's not enough." Thank you, and we're open to taking any questions.
Thank you for your very descriptive case example. Just to follow up on that, to me is an incredible email, but so a little bit more the human element. How did that just make you feel?
Well, the email made us all feel really great. Our fellow IJEC student attorneys who are also here had been working on that particular client's case since August of last year. So it was a long process that took a lot of hard work. And so being able to read how thankful she was and how happy she was, I think just goes to show again how important these clinics are and the impact that we're able to have on the lives of investors who think that there might not be an opportunity for them to recover the money that they've lost. And we're able to advocate on their behalf and give them hope. So our clinic was very happy and very proud to receive that email from her. And we're going to continue working on her case to get her the best possible outcome that we can.
Thank you very much.
And just to go back to the facts, concerning the clinical case you mentioned, could you tell us more about how you did your extensive investigation, kind of what it was like?
So prior to us approaching opposing counsel, we wanted to make sure we had as many facts as possible. We did believe that he was going to deny most of the allegations that we had against him, and so we had to speak to the investor and get his complete story, as well as reviewing all of his account statements. This is the part where the clinic and education really came together, because we also needed to learn a lot of the terms and a lot of the FINRA rules. And so in that process, we were investigating every single allegation, every potential FINRA rule violation to make sure that when we approached opposing counsel, we were able to give him the documentation that disproved what he was saying to get us to settlement negotiations. Thank you.
Well, thank you all for coming today and speaking for us. And we just want to thank you so much for all the great work you're doing for Americans. Thank you.
I'm Richard Dominguez, and I'm proud to be a member of the Investor Advocate team. And right now, I'm very pleased to introduce our next speaker, the current director of the Division of Investment Management, William Birdthistle, who will actually be departing us in about a week to return to academia. Chair Gensler appointed Director Birdthistle in December 2021 to oversee that division, which is responsible for administering the Investment Company and Investment Advisor Act of 1940. These laws impact Main Street investors every day through the regulation of products like mutual funds, variable insurance products, and exchange-traded funds, as well as investment advisors and the clients who entrust them with their money as they are acting as fiduciaries. Prior to joining the SEC in 2021, Director Birdthistle was a professor of law at Chicago Kent College of the Law, where his scholarship focused on investment funds, securities regulations, and corporate governance. In 2016, he published a book on mutual funds, Empire of the Fund, The Way We Save Now. And I don't know about you, but I think that's a fantastic title for a securities book. He has also taught at the University of Iowa and Chicago, and prior to academia, he was an associate at Ropes and Gray and a clerk for Judge O'Scanlan on the Ninth Circuit Court of Appeal. Director Birdthistle received his law degree from Harvard Law School, where he was also the managing editor of Harvard Law Review, and he also earned his master's in history from the University of Chicago and a BA in English and psychology from Duke University. I present Director Birdthistle.
Greetings, everybody, and welcome to the SEC. My name is William Birdthistle, and I'm the Director of the Division of Investment Management. Our division's responsibility is primarily to administer the Investment Company Act of 1940 and the Investment Advisors Act of 1940. I suspect if many of you are in law school or recently were in law school, those names will sound a little familiar to you, but not terribly familiar. They're meant to be in a course on securities regulation, but they typically only come at the end of the semester, and in most casebooks, they come after page 1000, which is a grave and terrible mistake that we try our best to remedy. Because as you'll see, our division is responsible for a lot of people's actual treasure. Our division primarily makes policy for the $30 trillion that are held in public investment funds, and those are funds like money market funds, mutual funds, and exchange-traded funds, the kinds of places where most people put their money in savings accounts and retirement accounts like 401ks and 403bs. The Investment Advisors Act, however, also gives us a responsibility and oversight of another $50 trillion that's held with investment advisors. So if you add up all that money, that's north of $100 trillion worth of America's treasure and life savings. It's a great deal of money, and it's a responsibility we take very seriously. So for that $110 trillion, there are about 230 people in the Division of Investment Management. So each of us has responsibility for something like $500 billion. It's not quite how it works, but that's how we like to think of it. Our division is divided into 5 offices, and they roughly have the following responsibilities. Our analytics office conducts a lot of quantitative and analytical research into the market to be aware of what's happening outside the building and what's coming our way. then our disclosure review and accounting office is the first line of staffers who see filings made by the industry when they want to launch new funds. So they're telling us a lot about what's actually coming in. And they're the first ones to know about new crypto filings, for instance, or new ETFs, and anything unusual that the industry is interested in taking live. A third office is our rulemaking office, and these are our colleagues who actually create, they propose, and help adopt the rules that the agency promulgates. We're one of 3 primary divisions that focuses on policymaking, together with trading and markets and corporation finance. And so the rulemaking office is a particularly important part of what IAM does. The fourth office is our chief counsel's office, and it's their work that helps implement the rules after they've been adopted, as well as interpreting rules that are already on the books and working with industry to find relief in particular areas where they would like no action letters or other kinds of exemptive relief. And then our fifth office is our managing executive's office, and those are the colleagues who help the rest of us actually do all the things that I just mentioned by keeping the lights on and giving us all computers and making sure that we're able to work. That's a quick overview of the Division of Investment Management. And one of our primary objectives is to ensure that investors are protected. Nevertheless, as I'm sure many of you know all too well, investors may encounter bad actors when they're seeking advice on how to invest their hard-earned savings. And that, of course, brings us to all of you who are here with us today. You at this summit know just how well and just how devastating the results can be when financial professionals disregard their fiduciary duties to their clients. So their clients are people who are trying to save and grow and safeguard their assets for most of life's greatest and largest and most sizable expenses. Things like buying a house, paying for college, or as you would all know very well, paying for law school, and of course for saving for retirement. When those financial professionals do abuse that relationship of trust, it's really vital that investors have effective avenues for recourse. And arbitration, whatever its challenges, is one such avenue. But financial services firms are almost always going to be better positioned and better resourced than any individual investor to pursue legal and practical challenges to accountability in these moments. Access to counsel, therefore, such as yourselves, can play a critical role in investors' ability to vindicate their rights and to obtain well-deserved recoveries. The clinics represented by all of you at this summit really need to be commended for helping address that need, especially for underrepresented and underprivileged communities. So I thank all of you for being here today and for all the efforts that you've made in this area. And for those of you who find your clinical experience particularly rewarding or impactful, I'd like to take a brief moment, but an emphatic one, to encourage all of you, after you're done with law school or later on in your career, to pursue a career in public service, whether at the SEC or anywhere else, but especially at the SEC, and particularly in the Division of Investment Management. I look forward to seeing your applications cross my desk someday soon, I hope. Let me take a brief moment now to introduce today's next speaker, the SEC's investor advocate, Cristina Martin-Fervida. Having joined the Commission in January of 2023, Cristina has recently completed her first full year in the role of investor advocate. But she's not new to public service or to investor protection. In fact, a quick glance at her CV will immediately show how that she is one of the most dedicated and public-spirited civil servants at the agency. Immediately prior to joining the Commission, Cristina was the Vice President for Financial Security and Livable Communities at the AARP, where she focused her advocacy on issues critical to retirement financial security. Prior to that, Cristina worked at both the National Women's Law Center and the Children's Defense Fund. Her career and experience are an archetype of the investor-focused advocacy, and the Commission and the nation's investors are so fortunate for having had her in our corner. I hope you enjoy the rest of your event, and welcome, Cristina. Thank you all.
Well, I am quite mindful that we all are already supposed to be in the other room enjoying ourselves together with refreshments. So I'm going to first thank all of our colleagues here at the SEC, and there's a long list of them. Before on behalf of my colleagues and my own behalf, I thank all of you for not just coming here to DC today, but for what you're doing every day. The list that we have from the SEC is so long because everyone here really values and appreciates what you are doing, not only right now for investors, but for the development of the next generation of securities attorneys and advocates. So, I attend many of these events. I will say that they don't all have, a panoply of directors and commissioners and chairs. So I want to first begin by thanking Chair Gensler, who is very supportive of the clinics and was very eager to invite all of you today here. And anyone who is listening or participating via webcast, particularly for those who do not currently have a clinic, I know that it was important to the chair that we do the outreach to the law schools that have clinics, but not a securities clinic, not an arbitration clinic. And so we thank him for his support. I want to thank Commissioners Peirce and Lizarraga, who very much wanted to have a one-on-one dialogue with the students. I know Commissioner Peirce was disappointed that she couldn't be here in person. We're very appreciative that Commissioner Lizarraga made time in his very busy schedule to join us here today. They enjoy the kind of dialogue that we had today via Q&A is exactly the kind of experience that you have when you meet them. And the thoughtfulness that they bring to that Q&A is how they approach the work of the commission. And I say that because, again, I'm sure you have heard a theme. Not only do we want to make sure that investors have the representation that you offer, but we're also very eager to have all of you join us here. So we want to always be highlighting what a fantastic place the Securities and Exchange Commission is, and Commissioners Peirce and Lizarraga's remarks, I think, really highlight that. I want to thank Directors Best, Bird Thistle, Gerwal, and Wise for providing remarks on their own experiences with the clinics, on the value of the clinics and the work that you all serve retail investors, and in introducing the panels. But in particular, I want to thank Director Girding, who I think his passionate remarks and his enthusiasm for all of you and his commitment to find us 2 more clinics, I think was palpable. I want to also thank our colleagues from the Office of Investor Education and Advocacy and the Office of Minority and Women Inclusion. We appreciated the opportunity to co-host this event with you today. And we also want to thank the Division of Exams for providing remarks and introducing a panel as well. All of our colleagues here are very committed to investor protection. It is, as you already heard today, it is only one of the 3-part mission of the SEC, but I think that the folks that you met today among our colleagues really care very deeply about investor protection and share that with you. I want to thank our keynote speaker, Professor Einaron from Drexel Klein School of Law. The synthesis of the problem of accessing representation and seeking redress was perfectly summarized in her keynote, and I am looking forward to sharing that with a number of our colleagues as we continue our advocacy in educating people both here at the SEC but throughout our sister agencies about the challenges that retail investors have with arbitration. And I especially want to thank the Ombuds, Stacy Pente, and her entire team, as well as other members of the Office of the Investor Advocate who have tirelessly worked to put this event together with all of you, co-create this event with all of you, while also doing their other all of their other daily jobs, which are myriad. And then, most of all, I really want to thank each of you for coming here today, for sharing your experiences, for telling the stories of your clients who are as you know all too well, are often unheard, for spending your time daily serving individuals who need help, for caring enough to consider perhaps a career with the SEC or in other avenues of public service, for being advocates and sharing your positive experiences with others in the legal field so that we can encourage others to also have clinics and reproduce these experiences at other schools. And from my perspective, provide more services to more retail investors. So I ask you to join us all in the multi-purpose room. Before we do that, to give yourselves a warm hand of applause. And we thank you for your time today.